were you so gainfully employed as a forensic scientist in Cuyahoga County, in the Cleveland area, back in 2024, 2025?
Yes.
And did you have the opportunity to talk to myself with regards to retaining you for the services of the evaluation of Bionca Ellis?
Yes.
And did you cause a report to be generated based on your findings with regards to the evaluation of Bionca Ellis?
Yes, I did. I authored a report dated July 8, 2025.
Right. And, Doctor, it is a 37-page report?
That's correct.
Your Honor, may I approach? Dr. Nossinger, handing you what's been previously marked and shown to the defense counsel, State's Exhibit 230. Do you recognize that document, sir?
Yes. Again, this is my July 8th, 2025 sanity evaluation, 37 pages in length. And I have another copy in front of me in my folder here as well.
Okay. And, sir, does your name and signature appear at the back?
Yes.
And are all of your findings based to a reasonable degree of medical certainty in forensic psychiatry?
Yes.
All right. So,
I could just ask, is the state moving him to be qualified as an expert under 702?
yes, Your Honor.
And is there any objection?
No.
Very good. I'll note for the record that he is deemed to be an expert and allow him to testify as one under Evidence Rule 702. So go ahead with your question.
Thank you. So, Dr. Nossinger, when you first became involved, what sources of information were
Well,
you...
I interrupted you, so I don't know if he gave his statement about what his finding was, where you were asking...
No, I just said, did he have a finding
of reasonable degree of
medical certainty? And he answered, yes, I believe.
I interrupted just because I wanted to make sure he was an expert.
Yeah.
We didn't do that. So,
Oh, I'm sorry. Thank you.
yes. So I apologize for interrupting. Go right ahead.
All right. So, Doctor, you have generated a sanity evaluation.
True.
Correct? What source of information did you examine and review in order for you to render your opinion in this matter?
The sources of information I have listed on the first 4 pages of the report, so I'll just go ahead and...
Well, let me ask. You want off?
I'd like to know the majority of the information that he reviewed.
So you want him to read the 4 pages is all I'm asking?
Yes.
I reviewed the indictments. I interviewed the defendant, Bionca Ellis, for 3 hours on June 12th of 2025. I reviewed records prior to the June 3rd, 24 offense, which included some hotline reports from the Department of Job and Family Services from 2007 and 2008, a Division of Children and Family Services reports from 2007 and 2008. I looked at the defendant's Cleveland School District records. I looked at some Frontier and Allegiant airline records from the spring of 2025. I then looked at some police records prior to the June 2024 offense. So Cleveland Police Department records from June of 2013, and then moving forward to 2024, I looked at Bakersfield, California police records from January 26th of 24. That included police reports, 2 videos from police officer body cams, and some evidence photographs. I looked at Cleveland Police Department records from February 24 of 2024, including police report and then 3 police officer body cam videos. I then looked at some police records from Florida, and I'm not certain how you pronounce this, Osceola, Florida County Sheriff's Department records from March 25th of 24, including police reports and then 2 body cam videos. I then looked at the defendant's medical and psychiatric records prior to the current offenses. So Cleveland Clinic records, which included her psychiatric hospital records from Lutheran Hospital from 2015, multiple Fairview Hospital records from the ER from 2013 up to 2023, other records from the Lutheran ER from 2015 and 2016. I looked at the psychiatric hospital records for Marymount Hospital, where the defendant was hospitalized from September 4th to September 15th of 23. Fairview Hospital medical hospitalization records in October of 23. Then a subsequent psychiatric hospital stay at Marymount Hospital from October 27th.
Going through the records, letting the jury know what those records show. We'll hit pause, go back in for more testimony next.
Donna Adelson was part of a conspiracy to kill her former son-in-law, Dan Markell.
He's not going to survive.
Oh my God.
Dan saw Donna as dangerous.
She's the matriarch mastermind.
She's just being a parent, not a killer.
Victim to Verdict with Ted Rowlands. Season finale, Saturday night at 8 Eastern and Pacific. And during the finale, don't miss an exclusive preview for the new season of Interview with a Killer, only on Court TV.
Welcome back to Court TV Live. Let's get you into the best moments of the Toddler Stabbed murder trial. We're also tracking another big case for you, this one out of Florida. I want to show you a live look at the courtroom for the hammer killing murder case. If you are a Court TV OG, Cordy, you remember this case. He looks different now, but look at the guy in the red jumpsuit. That is defendant Mark Sievers. Remember him? We broadcasted his trial for you in 2019. He was found guilty of orchestrating the murder of his wife, Teresa, who was beaten to death in 2015. Well, now Mark is fighting to have his conviction and his death sentence. Remember, he got the death penalty overturned. We're going to be sharing today's hearing with you after we get you caught up on that case in Cleveland that has everybody talking, the Toddler Stabbed murder case. With the Sievers case, if you're new to Court TV, you may not remember it. We have a little bit of information on that for you. The backdrop. Court TV's Michael Ayala has more.
I cannot feel remorse for something I had absolutely nothing to do with.
Mark Sievers was convicted of orchestrating the murder of his wife, Teresa, who was brutally killed in 2015. In 2020, Sievers was sentenced to death, but he says he is innocent.
Teresa is my soulmate. I will miss her and cherish our memories until we are reunited in heaven. Until then, I will fight this wrongful conviction until I am proven innocent and set free to rejoin my family.
Sievers was convicted of first-degree murder and conspiracy to commit murder. At trial, prosecutors told jurors Sievers hired his longtime friend Curtis Wright and hitman Jimmy Rogers to kill the 46-year-old doctor and mother of two. Wright and Rogers beat Teresa to death with a hammer. Evidence showed Sievers planned the crime.
Coded messages between Wright and Sievers on their personal cell phones. A shredded life insurance policy in Mark Sievers' office. Life insurance policies on Teresa Sievers' death totaling around $5 million.
Sievers' alleged motive, life insurance money, and custody of their two daughters. Wright testified against Sievers.
Mr. Wright, who killed Dr. Teresa Sievers?
Jimmy Rogers and I physically did it, but Mark Sievers was also involved in the planning.
Wright took a plea deal and was sentenced to 25 years in prison. Rogers was convicted of second-degree murder and is serving life in prison. And even though his prior attempts at proving his innocence have failed, Sievers and his attorneys are once again fighting, this time to have his conviction and death sentence overturned.
Although a jury found me guilty, I am innocent of all charges, as I've maintained since this heinous crime took place.
Oh, he says he's innocent. Okay, we'll see what the court does today. That hearing underway. We'll get back to it as soon as we finish up in Cleveland. Let's return there now. We have a forensic psychiatrist on the stand on behalf of the state of Ohio. We were just pausing that testimony to hit the break a couple minutes ago. What he was doing was looking back at the medical records, looking back at Bionca Ellis's history. Let's go back in.
All right. And so you indicate to this jury that you interviewed Bionca Ellis.
I did.
And did you videotape it?
I did.
And did you use the contents of that videotape to make some determinations?
Well, I used the content of the interview itself that I was, conducting, that was captured on video, yes, to make some conclusions.
Okay. And doctor, why is it important to videotape the defendant or the suspect that you are talking to?
Well, I don't videotape every criminal defendant, but in this case, there were substantial questions. There were substantial conflicts in the data between the contemporaneous evidence and Dr. West's report. And I wanted to capture that on videotape, my encounter with the defendant, to get her account of the offense, but also to ask her about some of the things that she had told Dr. West and some of Dr. West's conclusions. And so I wanted to preserve that on videotape because I thought it was especially important data.
Okay. And, sir, if I were to show you a couple of clips from your interview, do you want us to go to a certain part of that, or do you want to start with your report and your findings? What, after the interview, what did you do next, and what did you examine?
Yeah, why don't we go through the report?
Okay, fair enough. So, the statement of non-confidentiality, did you have a conversation with Ms. Ellis about that?
Yes, that's how we opened the interview, just to get her informed consent. In that, I informed her of a number of things. That, first of all, that it was being videotaped, and that what she told me was not confidential, that I'd be writing a report, so things she told me could be shared with others, either through my written report or any courtroom testimony. And that although I was a psychiatrist, I would not be her treating psychiatrist, but just doing this one-time interview for the purposes of her insanity defense evaluation. And because of that, then we did not have a doctor-patient relationship.
And did she understand what you were indicating to her and what you were telling her you were going to do?
Yes.
And did she appear to understand, and did she understand?
She appeared to, yes. Yeah.
And did she participate in answering your questions?
Yes.
All right. And what, not because we have a video, but can you just summarize for us your interview with her and what kinds of questions you were looking at? I believe you started off with social history. Why is social history important?
Well, it's part of any standard psychiatric interview to understand the defendant's social history as well as the other various histories that I gathered.
And did she speak about her family?
Yes.
Spoke about her mother?
Yes.
Spoke about her dad?
Yes.
And indicated to you that her dad had some mental illness?
Yes, that her father had schizoaffective disorder.
All right. And she told you about her marital status and things of that sort?
She was single, never married, yes.
Does she talk about where she lived on June 3rd of 2024?
Yeah, we talked about her travel and then how she had returned to Northeast Ohio, where she had an apartment in Rocky River, but that she was not living in.
All right. And then you inquired about her educational history.
Yes.
And you found out about her background. What did you learn?
That she had attended the Cleveland Public School District, that she was a good student, no major behavioral problems. She left in school in 10th grade, and she told me the reason she left was that she had believed that she had given birth to a large number of children, including that she had given birth to a child at school that had subsequently been taken from her, which I think is just one of her baseline symptoms of her mental illness. But she said that was the reason she left school, was she had bad memories of school because of that so-called memory.
Now, when you say baseline, what do you mean by that?
Well, she's had schizophrenia or schizoaffective disorder for a number of years. And so it looks like that she always, to some extent, has some degree of symptoms and then has periodic exacerbations where her symptoms become worse. So I interpreted her telling me that she had believed that she had something like 15 or 20 children over the years that had all been taken from her as just kind of a chronic delusion that she had.
Okay. All right. Then you talk about occupational history. And what
okay, let's pause the doctor's testimony here. Let's see what our legal eagles think. I want to bring in our attorney guests this hour, Nicole DeBoard and Rob Corbett. Good morning to you both. Share with us your thoughts, please, on this witness and his testimony so far. What do we think? Nicole, start us off, please.
He's going through very methodically what one of these examinations looks like, and he is acknowledging the fact that there is indeed serious mental illness present, and he is going to follow that up with information about why, despite serious mental illness, this is still someone who is competent to stand trial and can understand and assist their counsel during the trial procedure. So that is going to be the opposite of what we heard from the defense experts in this case in terms of whether or not she's capable of assisting counsel in such a way that they can actually try her for this crime.
Rob, share with us your thoughts on this witness, please.
First off, thank you for having me. Excuse me, and I would agree. He's doing an excellent job in terms of laying out all of the things in terms of that he used to come to his ultimate conclusion. The not guilty by reason of insanity are always an uphill battle. I believe less than 1% of all felony cases use this type of defense. And out of that 1%, it's only successful about a quarter of the time. And then plus you're dealing with the state of Ohio, which has a more restrictive view of that defense as opposed to some other states. So, but he's doing an excellent job for the prosecution in terms of laying out, in terms of despite any mental history she may have had, she is still going to be competent. She's been found competent in terms of to assist in her defense, and that this is not a viable defense that the jury should find, that the trier of fact should find to find her not guilty.
Rob and Nicole, stand by kindly, please. Much more to come with this witness as we really get into the meat and potatoes of why he's here and what he's refuting that was put forth by the defense team. Thanks for watching Court TV Live. We are your front row seat to justice.
I moved, and she stabbed him in the side of his face. And then she stabbed me.
Take a minute. I'm going to ask a question.
Oh, that was Margot Wood when she was on the stand talking about the day that she and her little son, Julian, were stabbed. This happened in a parking lot of a busy grocery store in broad daylight in Cleveland, Ohio. And the issue isn't whether this defendant did the stabbing. She did, and her team acknowledges that she did. The issue is whether she was sane at the time of the incident. Sanity is a backward-looking inquiry that goes to her state of mind at the time of the crime. She could be sane today, but the issue is whether she was sane on June the 3rd of 2024. And on the stand right now, we've got a rebuttal witness called by the state of Ohio. His name is Dr. Stephen Knopfsinger. We paused his testimony. Let's go back in.
You talk about occupational history, and what is that about?
That she had worked in various fast food restaurants. She also had earned a child care certification and had a child care business for a while, watching her aunt's 2 children. And she had also worked as a home health aide. That she had last worked in about 2019, and she had received SSI since about 2017.
Okay. And then you talked to her about her medical history.
Yes?
And does she talk to you about that?
Yes, she said she had hypertension, she had a heart condition called tachycardia, which is just basically a rapid heartbeat. She had adult onset diabetes, sleep apnea, gallstones, uterine fibroids. She had had some surgeries in the past for tonsillectomy and appendectomy, low back injury, and then later she told me she had POTS, which is postural orthostatic tachycardia syndrome, so variations in blood pressure and heart rate.
Okay. All right. Did she ever have any type of head trauma or loss of consciousness?
She said no.
All right. Current medications?
When I saw her in June of 25, she was taking Clozaril, which is an antipsychotic medication, and she was also taking medication for blood pressure and for diabetes, and then something called Cogentin, which is it's a medication for side effects of the psychiatric medication.
And you talked to her about some legal history and some travel history, doctor?
Yes.
All right. And why do you talk to her about some legal history?
The question is, why do I?
Yes.
That's just a part of a standard psychiatric evaluation to understand if the person has had prior arrests or not.
Okay. And travel history?
Yes.
All right. You talked to her about that and what she had been doing prior to June 3rd of 2024, correct?
Yes.
All right. And the places she went and the things that she did, correct?
Yes.
All right. Then you talk about abuse history.
Yes.
And what does she tell you about that?
That she believed that she had been abused emotionally as a child when she witnessed her mother and father fighting, which was stressful for her and caused her to be tearful. But she never had been physically abused as a child. She said in 2022 she was assaulted by a woman at Walmart, which she believed was physical abuse. I asked her about sexual abuse, and she said that she believed she had been raped by a family friend, but was uncertain if this was a real memory or simply a symptom of her mental illness.
Okay. And would that be a symptom of her mental illness?
Potentially, yes.
Okay, fair enough. Family psychiatric history important?
Yeah, again, she said her father had been diagnosed with something called schizoaffective disorder, which is a variant between schizophrenia and a mood disorder. Her father had experienced hearing voices telling him to kill himself, and had psychiatric hospitalizations to treat his illness. And there was a question about whether her paternal grandfather also had mental illness, because he tended to, she said, he tended to prognosticate and to make other somewhat strange statements.
Okay. All right. And substance abuse history, is that important?
Sure, that's part of any standard psychiatric evaluation. I took her substance abuse history, and it looked like, although she had used some substances in the past, nothing really close in time to the offense, so it wasn't really relevant.
All right. And then the psychiatric history then. And
Yes.
do you go through that with her?
Yes.
All right. And does she talk to you about the various situations that she found herself in, the various hospitalizations that she was in, inpatient and outpatient, talk to you about Murtis Taylor and going to Murtis Taylor?
Yes.
Okay. And did you verify some of that information through the documentation that was provided to you?
I did, yes. She described to me her various symptoms, which included hallucinations and delusions and depression. She described hospitalizations beginning in 2015 for mental illness and taking medications and outpatient treatment, and that appeared to be corroborated by the medical records which I reviewed.
All right. And then there's a mental status examination on 6/12.
Pausing the testimony right here. Don't go anywhere. More unaired footage from the courtroom in Ohio in the Toddler Stabbed murder case is next.
The defendant is guilty of first-degree murder.
Convicted for the murder of her former son-in-law. How long will the matriarch mastermind spend in prison?
Was it worth it?
The sentencing of Donna Adelson, today at 3 on Court TV.
Donna Adelson wasn't a regular mother.
She's the matriarch mastermind.
She's just being a parent, not a killer.
Victim to Verdict with Ted Rollins. Season finale, Saturday night at 8 Eastern and Pacific.
Only on Court TV.
I want to take you back into the courtroom now in Florida. Live look at the hearing for defendant Mark Sievers. You may remember this trial happened back in Florida in 2019 when he hired 2 hitmen to murder his wife, Teresa. Big case. He was convicted, sentenced to death, and he's got a big evidentiary hearing as he is still trying to proclaim his innocence and fight the penalty that was doled out to him. There's a look at Mark Sievers now. Looks a bit different than he did years ago when he was arrested for those crimes. And just getting his handcuffs taken off for this hearing. We're keeping an eye on it for you, filming it. We're going to be showing it to you later on today here on Court TV Live. Right now, though, we're in the trial in Ohio, showing you unaired footage from the case against defendant Bionca Ellis. She stabbed a little toddler named Julian Wood. The question is, was she sane when she did the stabbing? Let's go back in and hear more from the state's rebuttal witness.
And then there's a mental status examination on 6/12/25. Can you tell me about that, sir?
Sure. It's not really relevant to the sanity evaluation since it's not, it's done a year after the offense, but it's just a way of just describing her mental functioning whenever I interviewed her.
Okay. And just summarizing that, what were your observations of her on 6/12/25?
Well, she was somewhat withdrawn, but she was polite and pleasant. She had good hygiene. Her level of physical activity was a bit reduced. She spoke at a normal rate and pressure at speech, but at a low volume. So I frequently had to either ask her to repeat herself or to repeat her statement back to her. She said she was mildly depressed. She had an emotional blunting, which is characteristic of people with schizophrenia.
What does that mean, emotional blunting?
Just that she didn't display kind of a normal range of emotions, from smiling to sadness when appropriate, but just more flat.
And is that typical of folks that have schizophrenia?
Yes.
All right.
She did report to me things that I believe were likely to be delusional, such as giving birth to multiple people in the past, or multiple babies in the past, but did not have other delusions like paranoia or thinking someone could read her mind. She told me that when I saw her in June 12th of 25, she heard voices talking to her approximately once daily, saying things to her such as, "I'm your child," or "Don't give up." Sometimes the voices didn't make sense, and she occasionally saw the vision of a lion. And the rest of the mental status is me just assessing her for any kind of cognitive deficits like problems with memory or concentration, which she did fine on.
Okay. All right. And so do you also have a conversation about Murtis Taylor?
Well, just that she told me she had been there for outpatient treatment, yes.
All right. So, let's see here. So that's our psychiatric history. We've gone through the mental status. Then you look at police reports prior to 6/3/24. So you look at all the reports that are provided to you.
Yes.
And is there anything of note that you want to share with us before we get to your conclusions at the end?
Sure. So keep in mind, again, these are police reports from the months prior to the offense and in different locations. So we have the January 26, 24 Bakersfield, California police reports. And again, I also watched the body cam videos. So this took place at the Kern Medical Center in Bakersfield, California, where she was arrested. She had refused to leave the medical center property. Nurses told officers that Miss Ellis had.
Can I just jump in, Doctor?
Yes.
So I think the question was, is there anything in the police records that, and we could have it stated. I think you asked him, is there anything that stands out to him?
Yes.
Right. And so I don't know if everything as you're reading it, or is there something specific about the police reports that stand out to you with respect to your evaluation? Otherwise, I'm not stopping him from reading all of them, but I just wondered, was that the right question that I heard? And maybe it does, maybe all of it does. I don't know.
Well, I was getting to the fact that she had been aggressive, that she had behavioral problems, that she had assaulted hospital staff and refused to leave the property. And in fact, when she was asked to leave the property, she demanded that the police be called. So she was combative, punched the 2 security guards, and she then told officers that they needed to take her to jail because she had just assaulted hospital staff. So I think it's pretty striking behavior that, in fact, she even told officers that she wanted to stay in police custody for a minimum of 2 weeks, and even asked, what do I need to do to stay in jail? And she asked officers how much time she could get for resisting arrest. I think also noteworthy was her bizarre dress. She was wearing pink boots, a skirt, a sweater, and wig. So what was noteworthy to me was that, number one, she's physically violent. Number two, she's demanding that the police be called. And number three, she's seeking to stay in jail, which I think is very unusual.
Well, is it unusual?
Okay, so there's quite a history, as you can see, that this doctor's going through with Bionca Ellis. Let's just take a step back for a moment and look at everything we've already seen in the facts presented from the witnesses, the defense witnesses called saying she was insane at the time, and now this rebuttal, which we're still yet to hear more of. What do we think is going to be the end result? What might these jurors be thinking about this woman? Let's bring in our attorney guests and ask them. With me this morning, Rob Corbett and Nicole DeBoard. Rob, let me begin with you here, please. What do you think this jury's thinking?
I think ultimately the jury is going to lead or get to the conclusion that, yes, she does have a history of mental illness. Yes, she was presenting or exhibiting odd behavior. And yes, she had to have medication or what have you in order to be deemed competent to even go forward with trial. But I think based in terms of, and we're not quite there yet from this expert, but the expert is ultimately going to get to the point that despite having all of these things present, that she was still able to understand what she did was wrong. And that's the ultimate question in terms of what they have to consider when you're looking at whether a person can be found not guilty by reason of insanity.
Sure is. Rob, thanks. Nicole, tell us what you think the jurors may be thinking, please.
Well, first of all, Rob is 100% correct. And that is the big question, whether or not she knew the difference between right and wrong at the time, because they have to determine whether or not she was sane. This is just such a horrific case. There are jurors who are certainly thinking that they need to punish this person for this terrible, terrible crime. And that's just going to be very hard for some jurors to look past toward the question of whether or not she was sane at the time that it was committed. And so really they are going to be struggling with exactly the question that Rob pointed out, which is, did she know the difference between right and wrong at the time that she committed this horrific crime? Because if they find her to have been insane, then there is mental health treatment ahead, but a not guilty verdict as well.
Yes, Nicole, thank you for that. She won't be walking free. She'll go to a state hospital and be treated until she becomes well enough to be out in society. What a difficult case it is. Thank you both kindly for your analysis today. Rob Corbett, Nicole DeBoard, we appreciate you both. And friends at home, we appreciate you. There's more testimony ahead from that forensic psychiatrist. And as we head to break, we want to remember the victim, little Julian Wood. This little guy was 3 years old. He loved dinosaurs. He also loved the color green. He was taken from this earth far too soon, and he is deeply missed.
I said, do you know you stabbed that kid?
And what were your observations of her at that time? Did she look at you?
Yes.
Did she respond to you?
Yes.
What did she say to you?
With the shrug and mouthing so.
Oh, so what does that mean? Does that mean she knew what she was doing? Or does that mean she was out of her mind? Welcome back to Court TV Live. I'm Julie Grant. We're in Cleveland, Ohio for the case of the stabbing of 3-year-old Julian Wood and his mother, Margot. She survived, but sadly, Julian did not. And here, this is charged as a first-degree murder case. The defendant is Bionca Ellis. And her team isn't denying that she did the stabbings. She did. They fully acknowledge that. What they're refuting is her legal responsibility. They're claiming that she was insane at the time. The prosecution disagrees. They believe she knew right from wrong, and they've called a rebuttal witness to support that contention. Let's go back in now and hear more from Dr. Stephen Knopfsinger.
And so, Doctor, if we could, let's turn to page 33 of page 37 of your report. With regards to legal sanity, did you formulate an opinion in this matter, sir?
I did.
And what is your opinion, and what is it based on?
Well, I have opinions on both arms of the legal insanity test.
Okay, so let's start with the first part of the arm.
Yeah, it's my opinion with the reasonable medical certainty that the defendant had the severe mental disease of schizophrenia at the time of the 6/3/24 offense.
And what do you base that on, sir?
Several reasons. First of all, we have the defendant's report to me. She reported a history of schizophrenia or schizoaffective disorder that she had had for many years before the offenses. And the symptoms she reported, including various hallucinations and delusions, fit with the diagnosis of schizophrenia. She also reported that she had been psychiatrically hospitalized and received treatment with antipsychotic and other medications, all kind of consistent with schizophrenia. So that was one part of the reason.
Now, doctor, isn't that just self-reporting?
That's self-reporting, which we don't rely on, but we take it as one piece of data, and then we look for the presence or absence of corroboration, which in this case there was.
Okay, and that's looking at all the records, correct?
The medical records and the statement from her mother, who corroborated that the defendant had schizophrenia. And then, of course, what we know about it, that once it's diagnosed, it tends to be a lifelong illness.
So there is no question that Bionca Ellis has schizophrenia. Can we agree on that?
We agree.
Okay. All right. So your next point then, sir, with regards to your opinion.
It's my opinion with reasonable medical certainty, however, that the defendant did not have a severe mental disease or defect at the time of the June 3rd, 2024 offense that caused her to not know the wrongfulness of the offenses. So despite having schizophrenia, it did not cause her to not know the wrongfulness of the offenses.
All right. Can you explain that now to us, how you have formulated that opinion, sir?
Well, there are several reasons for it, and let me break this down here. First of all, the defendant had a rational motive for the offenses that was unrelated to her severe mental disease of schizophrenia. And there's multiple pieces of evidence that would support that rational motive.
All right, so let's talk about them. What did she tell you?
Well, she told me when I interviewed her on June 12th of this year that her rage caused the stabbings. Rage took control of her to make her do the, quote, wrong thing. She, quote, blanked out which she further explained, meaning that she experienced rage and anger. She, quote, blanked out and her rage took over. She felt rage and blanked out because before the offense, she was hot, dehydrated, had slept outside the previous night, had not eaten that day, and was worried about not having to pay any money and being unable to pay her rent.
Now, doctor, before we go on to B, all those things, some of those are self-report. Don't you need corroboration for that?
There is some corroboration, but I think we can also have higher confidence in motives that people self-report that are not helpful to their case, whereas if they promote a self-serving motive, then we kind of have a reason to question that and look for more corroboration.
Okay. 1B.
We look at the victim and witness accounts of the offense, which whenever I reviewed them indicated that she appeared angry close in time to the offense. So we have witness statements, first of all from Diane Spahar, the Volunteers of America store employee, told officers that Miss Ellis looked angry and distraught as she walked through the store with the knives in her hand. And then secondly, Margot Wood told officers that the defendant had an evil look on her face during the offenses, which would be consistent with anger and rage.
Well, is it consistent with schizophrenia, sir?
It's independent of schizophrenia.
How so?
It's not a symptom of schizophrenia. Anger and rage, or anger control problems and rage, are not symptoms of schizophrenia.
All right. Then you go on to C and D.
Well, thirdly, when you review the video footage from Giant Eagle and Things Outlet, to me it looks evident that the defendant does appear to be unhappy and walked in an angry, purposeful fashion, and certainly not a disorganized fashion. And then fourthly, if you look at simply the timing and sequence of events, what happened in the minutes, the 20 or so minutes before the offense, it all kinds of lines up why she would be upset. So we know that she was in the North Olmsted Police Station lobby from 1440 to 1444 hours, seeking to retrieve items she believed had been wrongly taken from her when she had been recently in jail, including cash and a gift card that she valued at $700 that she said she had to have to pay her rent and purchase food and water with. And we know that she was turned away in the lobby because the police officer that handles those complaints was not there that day. And they told her, we don't know anything about your missing items. So she was unsuccessful in her effort to retrieve her missing items from the police station. We then have directly after that, it's all on video, she goes through the parking lot, gets out of her wheelchair, gets rid of her luggage, and goes over to Volunteers of America, where she's seen walking through the store, selecting the 2 knives from the Volunteers of America. We have her then, only a few minutes later, entering the Giant Eagle store with 1 knife in hand, and then locating the victims in the Giant Eagle outside by the cash registers there, doing a 180 and turning and walking behind them, following them out, and then committing the offenses at 1,500 hours. So the close relationship in time to the defendant's unsuccessful efforts to retrieve her missing $700 worth of items, the close relationship with that, with getting the knives and then committing the offenses, coupled with her acknowledged rage and anger, to me indicates a causal relationship between her rage and anger and the offenses. In fact, she's still angry about it the next morning when she's interviewed by Detective Jones. She continued to focus on her perception that she had been victimized, that she was missing 700 items and demanding an investigation and appearing to me to be angry.
Appearing to you to be angry, sir, that's subjective, correct?
It's an observation, but it's, I guess it's open to interpretation, sure.
And was she disorganized in that interview with Detective Jones?
I don't believe so.
And what would you be looking at if she was disorganized in her thought process?
Kind of a word salad, just sentences not making sense, maybe some disorganization in her behavior as well.
But she's focused in that interview.
She's focused on getting back what she believes is her missing items, and then when she's asked about the offense, she simply asks for a lawyer, which appears to be organized.
Okay.
Oh, so this was big. This right here, what we just saw, was the big moment of this doctor's testimony, saying that it was Bionca Ellis's rage that caused the stabbings, not schizophrenia. He's saying that rage isn't something that's part of schizophrenia. He's making it very clear that this is separate and apart with what she's been diagnosed with. In her words, she's saying that's what occurred there in his interview with her. All right, so what's the jury gonna think of this? Let's bring in Sonny Slaughter and Marlo Greer. Good morning to you both. Sonny, let me begin with you. What'd you think of this testimony from the doctor?
Good morning, ladies, and good morning, Courties. I think this is excellent. And it also goes into what I said last week, that she became angry when she was at the police department and could not get her property back. That is when this whole thing started for her, that she wasn't angry during the stabbing, that she knew what she was doing. And I'm so glad that this doctor is really clear that rage is not a part of schizophrenia, which is the disease and diagnosis, and that these two are not the same, which means we need to stop saying things about people being crazy and it having to do with disease and diagnosis, which then people always equate to violence. And people that have disease and diagnosis are not always violent, and we need not say that about individuals all the time, just kind of happenstance.
Right. Marlo, want to get your thoughts, please. What do you think the jury may be thinking hearing this bit of testimony from the doctor?
My thoughts are that they need to have a reason why, and I don't know that just being upset over missing items is going to give them that. I think they have to have some other explanation, and the explanation is the schizophrenia. So then the question really becomes, did she know what she was doing at the time? I don't think they're going to discount the schizophrenia just because it does answer the why question, which we all so much need as human beings. But the question then becomes, did she know right from wrong? And I think that this doctor's testimony, regardless of any diagnosis, she knew right from wrong when she committed this act. She said there was a disconnect in her brain. She was struggling with her brain. So I think that that's going to be the focus, is the right from wrong at the time, not the schizophrenia generally, because that does give us a why, even if it's not exactly right, but it answers that fundamental question of, why did a child have to die?
Yeah, it's just unspeakable, Marlo. It really is. And we're going to get into some of Bionca Ellis's own words in just a moment here. Apparently, this doctor's video evaluation with her is going to be played for the jury. So we're going to get to hear it straight from the horse's mouth, so to speak. He just testified that she told him she blanked out, her rage took over, she had no place to go, she was hot. And so he's saying rage, anger, not symptoms of schizophrenia, saying that she did know right from wrong at the time. Now, we know this is not what the defense team says, so this is what it's coming down to. Which expert is more effective for this jury? What is this jury going to believe in terms of the facts and this expert testimony? So we'll hit the pause button here. We'll hit a break. When we come back in, we're going to watch that video played for the jury, and you're going to see and hear from Bionca Ellis. Be right back.
The defendant is guilty of first-degree murder.
Convicted for the murder of her former son-in-law. How long will the matriarch mastermind spend in prison?
Was it worth it?
The sentencing of Donna Adelson, today at 3 on Court TV.
Donna Adelson wasn't a regular mother.
She's the matriarch mastermind.
She's just being a parent, not a killer.
Victim to Verdict with Ted Rollins. Season finale, Saturday night at 8 Eastern and Pacific.
Only on Court TV.
It is great to have you with us on this Monday morning. Welcome back to Court TV Live. I'm Julie Grant. Let me show you the trials we're tracking for you right now. In Wisconsin, we've got the caught in the crossfire murder trial. This is for defendant Parise Larry. This guy's accused of killing Tatiana Zek outside of her home. In Florida, we've got defendant, convicted killer Mark Sievers back in court. This guy's fighting to have his conviction and his death sentence overturned. You might remember him from his trial. This case was one of the first ones we aired after we relaunched in 2019. He was convicted of hiring 2 hitmen to murder his wife, Teresa. And also happening in Florida, we've got the sentencing for Mama Donna Adelson getting underway at 3 p.m. Eastern Time. You can count on Court TV to be there for it all. Right now, we want to take you back to Ohio for the homicide case for the death of 3-year-old Julian Wood. Darling little child stabbed to death in a grocery store parking lot. He was stabbed by a woman named Bionca Ellis, and the question is, was she sane at the time that she stabbed him? We're hearing some unaired footage from the state's rebuttal witness. This is Dr. Stephen Knopfsinger. And when we go back in, you're about to see the videotape of the evaluation he did on Bionca Ellis. Remember, his opinion is she knew right from wrong. He's saying she was enraged at the time of the stabbing. She was mad about her day. She had slept outside the night before. She was hot. We know that she came from the police station upset. He's saying, yes, she did suffer from schizophrenia, but that rage wasn't a symptom of it. Let's go back in.
Number 4?
4 is, this is the 4th reason why she didn't have the severe mental disease at the time of the offense, which caused her to not know the wrongfulness. There was no psychotic motive which caused her to believe that the offenses were right. And there's different types of motives. There's rational motives, there's psychotic motives, but the defendant still knew that they had done something wrong. And then there's psychotic motives which cause someone to think they're doing the right thing. And only the latter one constitutes insanity. So in this case, there was no psychotic motive which caused her to believe that the offenses were right. Now, she did report to me when I interviewed her on June 12th of this year a number of symptoms. But even if you accept those symptoms at face value as accurate, which, part of them were not corroborated by the contemporaneous evidence, but even if you take them at face value as accurate, none of them would indicate she had a psychotic motive which caused her to believe that the offenses were right. So she reported to me anxiety at the time of the offense, that she was thinking of cutting her arms, this loss of control of her body, visions of herself dying in planets and a black moon, and Satan killing her, visions about, hearing voices telling her to kill herself, feeling like she was overthrown by a monster that was stronger than me, the single voice of Satan telling her to kill herself, the strong presence from the spirits, especially Satan, that stopped her from dropping the second knife. But again, even if you accept that she experienced these symptoms, which again, they're not corroborated, but even if you accept them, had she experienced them, they would not have caused her to believe that committing the murders and the other offenses was the right thing to do. So, for example, if she heard voices telling her to kill herself, that would not cause her to believe that it was right to kill the victim. There's simply no connection there. Or feeling that Satan was present, telling her to kill herself, or that she had a loss of control of her body, that would not cause her to believe that it was right to commit the offenses.
But what if she was in a psychosis or disorganization? Her thoughts were all over the place because of her mental illness.
Well, keep in mind the legal test for insanity is not psychosis. It's not disorganization. It's very specific. It's, did she have symptoms of a severe mental disease or defect at the time of the offense that caused her to not know the wrongfulness of the offense? So not all psychotic symptoms would meet that test, and certainly thought disorganization would not.
Okay. And you have, I believe, did you hit B and C of number 4, sir?
Yes.
Okay. So number 5 and number 6.
Well, number 5 is I asked her on June 12th, and this is on the video, did you know at the time of the offense that it was against the law to stab other people? And she clearly said yes. She knew that it was illegal.
Okay. And so, Doctor, before we get to a few other opinions, we're going to play just a portion of the video. We're going to start, this is State's Exhibit 204. It is 3 hours in length. We are going to start, hold on a minute, at 2:23:45.
Do you want me to introduce it first or just play it?
Well, I'm going to ask you as soon as Julian just gets it ready. All right, Doctor, are you in this video?
Right, there's a small cutout there in the bottom left, so I'm there in the extreme bottom left in the white shirt.
And where was this interview conducted, sir?
In this building at the Sheriff's Department.
And who was present for this interview?
Just me and Miss Ellis.
Okay. And is that customary to meet with the suspect by yourself?
Yes.
All right. And so we're going to play at 2:23:45, and we're going to play to 2:57:30.
You're going to play continuously?
Yes.
2:23 to 2:57.
Yes, that was the agreement that was reached.
24 minutes.
Yes.
Go ahead.
So, Doctor, when you're at this particular point, what point in the interview are you at here?
Right, so we've been talking for 2 hours and 24 minutes. So the first hour and a half, we had gone through the informed consent and all the background histories. And right about 1 hour 50, we started talking about the offense, and that was the rest of the interview. So we had a total about 1 hour and 10. So at this point, we're about half an hour to 40 minutes into it. And so we've already gone over the much of the offense already. And I'm going back and asking some clarifying questions. And she's, up to this, she's told me that she blanked out, that something took over control of her body. And so later on, we kind of talk about that in some more detail. But
so again, you're going to play continuously, no discussions, right?
Correct. That was the agreement by the parties.
Okay. Yeah, that's what I thought. Okay, go ahead. Thanks.
So what happened? By accident, So I'm just trying to understand.
You want to pause it for a moment? So, Ms. Mateo, yeah, turn mine up. Let's see if does it go any hot louder. I can't. Right there. So I put it. Were some of you having problems hearing it? Yeah. So this is the maximum. So let's go from here.
So what happened? By accident, So I'm just trying to understand. Did you know there was laws against stabbing people at that point? Yeah. And everyone knows that. Even kids know that. So you knew it was illegal. Did you have any thoughts that they were going to attack you? Or did you, again, my question is, did you have any thoughts that they were going to kill you?
Okay, so this is the videotape of the interview that testifying expert witness did with Bionca Ellis, and we acknowledge it's very hard to hear. You could hear them in the courtroom having a hard time turning up the volume for the jury. So what we're going to do is fast forward a little bit to a portion where we can hear things a bit better and kind of summarize what we're learning from this interview for you. Don't go away. This is Court TV Live. We are your front row seat to justice.
I saw a woman stabbing a mother and child. I saw the knife covered in blood. I saw violent motions towards a mother and her child.
This is a battle of the experts we're seeing in Cleveland, Ohio, in the case against defendant Bionca Ellis. Experts on both sides agree that this woman was suffering from schizophrenia at the time. But where they disagree is the effects of that mental disease. Because Bionca Ellis's own words were that she was feeling rage. Her rage took over at the time of the stabbings. And this doctor on the stand is saying rage isn't a symptom of schizophrenia, that it indicates that she did know what she did was wrong. So let's go back in now. We've kind of fast forwarded that tape to the point where we can hear it a little bit better. Let's go back in.
Was the stabbing like a way to express your rage? Were you frustrated? But I'm still left trying to kind of make sense of this. Is there anything else you can do to explain this? So, for your lawyer defender to plea of insanity, what do you think about that? Is that something that you see as a positive or a negative outcome? Do you know if you're convicted of this kind of offense?
That's it. All right. All right, Dr. Knopfsinger.
Why don't we take a minute? You want to stand up and stretch your legs, anybody? Readjust. Get you back into it here, please. Sure.
Now, Dr. Knopfsinger, suffice it to say that we just saw, give or take, 20 minutes of that interview. But in fact, that's a 3-hour-long interview that you conduct with Miss Ellis. Is that fair?
Correct. And again, the last hour and a quarter was over the offense. And so this is just the final part of discussing the offense.
Okay. And, sir, with regards to, I believe you mentioned hindsight, and then Dr. West actually mentioned hindsight bias. What does that mean?
Hindsight bias is someone knows the outcome of an event and then form opinions about people's conduct that took place before the event.
Okay.
And it's something we try and avoid because you have to place yourself in a person's shoes, what they knew at the time, not having knowledge of the bad outcome, the bad event later.
Okay. And with regards to rational or irrational connections, with regards to your interview with Miss Ellis on June 12th of 2025, was she able to relate to you where she was in her mindset with regard to the incident?
She was ultimately, yes. We had a good hour of her basically not wanting to talk about it, saying, I blanked out, I lost control. And to me, that it just doesn't explain the situation. And so I persisted through the course of that hour and pushed back and said, wait a minute, this doesn't make sense. This is not a symptom of schizophrenia to blank out or to lose control. And we finally have there at the conclusion then her, I think, finally saying what really happened, which was that her rage took over. She was angry about about her situation, and that was the motive for the offense.
And that's corroborated with the other information that you have in this case.
It's heavily corroborated by, first of all the absence of objective signs of mental illness during the offense, all the video, how she interacted with the police, the witness statements, and the fact, again, that she does look to appear to be angry, and by the offense itself, three stabbings.
3 stab wounds.
Yeah, this is really, really bad, what happened to little Julian Wood. What are you convinced of at this point in time after hearing from both sides? So they're agreeing on the diagnosis, but disagreeing on whether she suffered from that disease or defect in her mind that would cause her to not know the difference between what's right and what's wrong. Share with us your thoughts on social media. I've seen some of them coming in this morning. I appreciate all the insights from all of you members of our Cordy family. Let's bring in Sunny Slaughter and attorney Marlo Greer. Great to have you both on the show this morning. Sunny, start us off, please. Your thoughts at this point as we're getting more information from Bionca Ellis.
You know, once again, I want to say how horrific this is for little Julian and his family. They will never be the same. He is gone forever, and I really hate this. But unfortunately, this is a woman that does have a disease and diagnosis. I'm sure she has had this for a very long time. And what I believe is that she knew right from wrong at the time of the incident. I believe that she was angry. I think that the jury is going to see that. And they're going to understand that, even though it's complicated. And we all know someone with a history of disease and diagnosis around mental health. We all know someone, even if they're in our families, or we know someone that knows someone. So this is not foreign to us, but this crime is horrific and heinous.
Right, it sure is, Sunny. I've seen several Cordys agreeing with your analysis on this one, sharing their comments. And we really have to dive deep into this one, don't we? Marlo, when we think about the inquiries here, you know, it's not as simple as just she was unwell. Well, yeah, I think anybody could take a look at her and see her swinging the knife and the giant eagle and know she was unwell. But the question, as we were discussing earlier, really has to unpack so many layers of her mental health and what she believed and perceived at the time, doesn't it?
It does. And was she unwell at the time? And is that when she actually committed the stabbing? Is it when she walked up? You asked everybody's thoughts, you know, what's going on in your mind, and I just kind of want to weigh in on that, which is my thought is this doctor is such a seasoned expert witness. I don't know that the jury will see this, but the one thing that stood out to me was the fact that when the video came on, he said, oh, do you want me to introduce it first or just play it? And as lawyers, we know that what we have to do is something that's super boring called lay a foundation. He already knew that. And the other thing that I'm struck by is that he's saying a couple things that a quick Google search would reveal aren't accurate. And while the jury is not supposed to Google, the question is, what is the defense going to come back and say? He indicated rage is not a symptom of schizophrenia. Aggression is a symptom of schizophrenia. And that's, you know, again, a quick Google search. The blanking out, which is also a symptom of schizophrenia, but he said that it wasn't. And so is he going to go too far and therefore give the defense something to pick at? And the other thing that struck me, if I may, is that one part of her brain is saying this is wrong, and the other part is saying, do this. What do you do with that as a juror?
These jurors are going to have a lot to think about here. This is tricky. I see why this went to trial. I really do. I know that Bionca Ellis has excellent counsel. I know that. Her counsel is very, very, very seasoned. They've done a great job for her. So I gotta tell you, I wouldn't be surprised if this jury goes either way. There's more from the doctor on the stand called by the state of Ohio. So we're gonna watch that. Marlo and Sunny, thank you so much. We'll be right back with more Court TV Live. And here's a look at the victims as we head to break. That is Margot Wood with her 3-year-old son, Julian. He is certainly not forgotten as we progress through this trial. He would be 4 years old if he were alive today.
I'm going to ask you a lot of intensely personal questions. How do you explain it? The worst crime anyone can imagine. Do you feel like you took the fall for this murder? Tell me in your own words, what happened? Let's get started.
Interview with a Killer. New season premieres Saturday, October 25th. Only on Court TV.
Before we get you back to court, I have some updates for you from over the weekend regarding the case against former NFL quarterback Mark Sanchez. Look at this. This is his booking photo because he was booked over the weekend, had to be processed in the jail, but then released from custody. He's a current analyst for Fox Sports, stabbed after police say that he attacked a truck driver in Indianapolis the previous weekend. He's looking at a felony battery charge as well as several misdemeanor charges for what prosecutors say was all over a parking space. Sanchez had to be hospitalized with stab wounds to his upper right torso. This was from Sunday, this photo taken with his booking. This is a photo taken from the hospital of the victim in this case, the truck driver who his legal team says he was permanently disfigured from this attack, and they have filed a civil lawsuit on his behalf. So Mark Sanchez looking at problems both in criminal court and in civil court. We'll keep you posted as the case progresses. In the meantime, we're in Ohio for a homicide case over the death of a little 3-year-old child named Julian Wood. Question is the defendant someone who didn't know right from wrong at the time she stabbed little Julian? We got the state's expert witness on the stand on rebuttal. Let's go back in.
3 stab wounds.
Three actions would, to me, be consistent with rage.
And, doctor, therefore, based on a reasonable medical certainty, did you come to your final opinion in this case, sir?
I did.
And what was that opinion?
Well, for all the reasons we've gone over, it's my opinion that at the time of the act, Bionca Ellis had a severe mental disease of schizophrenia, but it did not cause her to not know the wrongfulness of the offenses.
And, sir, just briefly, you know that Dr. West authored a report.
Yes.
Did you review that report prior to preparing your report?
Yes.
And what were your observations with regards to her report?
I have some concerns both about her methodology in doing the assessment and some concerns about her opinions.
All right. So let's talk briefly about the methodology.
Well, first of all, we have only a she didn't number the pages, but I think I counted them. 16-page report.
Correct.
So I think that's a very sparse treatment of a very complex situation involving very serious offenses. I think it did not get the analysis, the full analysis that it deserved. Secondly is that although she lists in her sources of information all the video evidence, she really gives it no consideration in her report. And I would argue that is the most important evidence, the contemporaneous evidence. We have on page 10 and 11 of her report and the first quarter of page 12, her treatment of what she calls the collateral account of the offenses, which is her summary of the police records. So the police records and the video in this case were voluminous, and yet she attempts to summarize it down into 2 pages. She doesn't even say that she didn't do her own analysis of the video. She simply describes the police officer's description of the video, not Dr. West's own interpretation of the video. But even more importantly, in her opinions, she never incorporates all the contemporaneous data into her opinions. She relies heavily on what Ms. Ellis told her, her self-report made, I believe, 8 months later, that is largely uncorroborated by the contemporaneous evidence. And then finally, there's just holes in her reasoning. She makes an opinion and then attempts to lay out some evidence, but the evidence, in fact, does not support the opinion she's trying to make.
And is it fair to say, doctor, that in that report, a lot of the evidence that she relies on is the self-reporting of Bionca Ellis?
Exactly. Point one, she makes 4 subpoints, A, B, C, and D. Every one is Miss Ellis stated, Miss Ellis stated, Miss Ellis said that, Miss Ellis reported. And that's a fundamental error in doing sanity evaluations, is you don't rely solely on what the defendant says. You instead look for corroboration in the contemporaneous data. But then even the points, even if you accept it, at face value is accurate, it still doesn't indicate that the defendant didn't know the wrongfulness of the offense. So 1A is Miss Ellis stated that she was experiencing auditory hallucinations, noting someone's got to die, which made her feel very afraid. Even if she did that, how does that get her to believe that the offenses are right? Secondly, Miss Ellis stated, my brain just snapped. I went blank. I had no control.
All right, and so we're going to see the cross-examination of this doctor tomorrow morning when court resumes. They have the day off today for the holiday. In the meantime, here on Court TV, we're taking you to Florida for a brand new case. This is an evidentiary hearing for a defendant who's not brand new, Mark Sievers. Be right back.
Mark Sievers, ooh, there's a flashback. Welcome back to Court TV Live. I'm Ted Rollins. Good to be with you on this Monday. It's a holiday. Many jurisdictions, courthouses are closed for Columbus Day, but not all. And we are going to begin the hour in Florida, where a man convicted of orchestrating his wife's death is back in court today asking for a new trial. You remember this case. Mark Sievers was found guilty back in 2019 of plotting with his friend Curtis Wright and a hired hitman, Jimmy Rogers, to brutally kill his wife while Sievers was out of town. Sievers has maintained his innocence and now is pointing to new statements from Rogers, where he reportedly claims that Wright acted alone in a spontaneous act of violence. We're going to go to court and watch this hearing play out. Basically, Sievers is asking for relief. He was sentenced to death in this case. It's been a while. Let's get ourselves caught up with the case against Mark Sievers, and for that we'll turn to Court TV anchor Michael Ayala.
I cannot feel remorse for something I had absolutely nothing to do with.
Mark Sievers was convicted of orchestrating the murder of his wife, Teresa, who was brutally killed in 2015. In 2020, Sievers was sentenced to death, but he says he is innocent.
Teresa is my soulmate. I will miss her and cherish our memories until we are reunited in heaven. Until then, I will fight this wrongful conviction until I am proven innocent and set free to rejoin my family.
Sievers was convicted of first-degree murder and conspiracy to commit murder. At trial, prosecutors told jurors Sievers hired his longtime friend Curtis Wright and hitman Jimmy Rogers to kill the 46-year-old doctor and mother of two. Wright and Rogers beat Teresa to death with a hammer. Evidence showed Sievers planned the crime.
Coded messages between Wright and Sievers on their personal cell phones. A shredded life insurance policy in Mark Sievers' office. Life insurance policies on Teresa Sievers' death totaling around $5 million.
Sievers' alleged motive, life insurance money, and custody of their two daughters. Wright testified against Sievers.
Mr. Wright, who killed Dr. Teresa Sievers?
Jimmy Rogers and I physically did it, but Mark Sievers was also involved in the planning.
Wright took a plea deal and was sentenced to 25 years in prison. Rogers was convicted of second-degree murder and is serving life in prison. And even though his prior attempts at proving his innocence have failed, Sievers and his attorneys are once again fighting, this time to have his conviction and death sentence overturned.
Although a jury found me guilty, I am innocent of all charges, as I've maintained since this heinous crime took place.
All right, there he is, Mark Sievers. He says he should not be on death row, that these guys acted alone, and specifically Jimmy Rogers acted alone in a fit of rage. How'd they know his wife was gone? Well, let's watch this play out before we judge. Here is the Sievers' lead counsel during his trial has taken the defense, the stand now for the defense here. Let's go in and listen together, see where it's going.
And just to reiterate, you said you didn't recall any sessions on a defense or experts for crime scene.
No, so the Mr. Sievers' trial was approximately 6 years ago. This would have been further back in time than that, so I don't have a lot of specific recollection about exactly what was presented, other than they spent a significant amount of time on jury selection.
Okay. Initially, what was your role in Mr. Sievers' case?
Well, initially, I was just the attorney who was going to primarily handle the case. I don't want to speak on Mr. Fega's experience, but I know that I had more recent trial experience than Mr. Fega, and so it was contemplated that I would be the one who would be basically trying the case.
You just mentioned you had more recent experience than Mr. Fega. What was Mr. Fega primarily practicing at that point?
He was primarily doing transactional real estate. He had a general practice, so he did some family law and civil litigation, but day in, day out, he was doing real estate transactions.
Did he have any criminal experience?
Yes, he did.
Now, when the state filed the notice to seek death, were there any conversations, either internally or externally, to come off of Mr. Sievers' case?
I don't recall. And by conversations, do you mean with Mr. Sievers, or do you mean within the firm?
Either internally or externally.
I really don't recall. I remember getting the indictment, going to see Mr. Sievers. We talked about it, and at that time when the indictment came down, I had a pretty good idea that a notice to seek death would be imminent. I don't believe that we had that conversation, but again, it's been many years since that indictment came down.
Okay. Were there any conversations to bring on a death qualified attorney?
Yes.
Was one brought on?
Yes.
Who was that person?
Ultimately, it was Mr. Attorney Gregory Masor.
And how did he come on the case?
I believe Greg reached out to us and offered, and of course we were more than happy to accept the help.
Was there any kind of vetting or interview process?
Again, it was a long time ago. I don't have a lot of memory. I do remember over the years having several conversations with Mr. Masor, and you know, I think we were able to effectively work together.
And at some point, when Mr. Masor came on the case, was Mr. Fega still on the case, or had he passed on at this point?
I don't remember. I'm sorry. I do not remember. I know Mr. Fega passed away in October of 2018, I believe. But I don't remember when Mr. Masor came on the case.
Okay. Prior to Mr. Fega passing away, how were the roles divided in this case? Were you responsible for one thing? Was he responsible for another, or did you just take all of it?
By he, do you mean Mr. Fega?
Mr. Fega.
No, I was primarily responsible for everything. However, you know, Mr. Fega at that time, still being my boss, ultimately had some veto power. But I was the one who ultimately, it was my case, so ultimately it's my responsibility.
So were you the one doing all the research?
Yes.
Reviewing discovery?
Yes.
Looking into any experts, if any, to contact?
Yes.
Okay. And you said you were unsure if Mr. Masor was on the case at this point?
Yes, and I'm sure he entered a notice of appearance of co-counsel, so that would probably be the best evidence of when he came on board.
Okay. After Mr. Fega died, how were the duties divided?
It was me.
What was Mr. Masor in charge of?
So Mr. Masor was doing the mitigation. So as I said, I had a significant amount of trial experience, including a murder case. However, I had never done mitigation. So we believed it was best to have the person who's already done the mitigation do the mitigation in this point, just for familiarity purposes.
Were you given Did you give any direction to Mr. Masor, or did you just say go do the mitigation and run with it?
No, we worked together on it, and I'd like to think that I had some input, just the same way that Mr. Masor had input on the guilt and innocence phase.
What input did you have on mitigation?
So one of the decisions we had to make was hiring a mitigation expert. Believe we landed on, one second. Oh God, his name is escaping me right now. I do apologize. Jeff Giordano. Jeff Giordano was our mitigation specialist, and we talked to Jeff, and we agreed that Jeff was ultimately a good person to do this job after we had several people who weren't.
So he was not the first mitigation specialist?
He was not.
How many people preceded him?
2.
Do you recall how the time in relation to trial beginning that Mr. Giordano was brought onto the case?
Again, not with a lot of specificity. So I know he was our 3rd mitigation specialist, but again, the exact when, I could not tell you.
Okay. You also mentioned that Mr. Masor had some input into the guilt phase portion.
Yes.
Were you mainly in charge of guilt phase?
I was.
Who made the ultimate decision as it related to guilt phase?
That would be me.
And what kind of input or suggestions was Mr. Masor given? During jury selection,
Mr. Masor and I discussed every juror, and his input was invaluable. It's always nice to have another lawyer to bounce ideas off of. Okay, did you notice anything about this potential juror that maybe I missed? So in that respect, and I do remember, certain witnesses having conversations. Brief conversations at the table. So yes, Mr. Masor is quite helpful.
Was his role limited to jury selection?
No. Again, we discuss witnesses, and this was a long time ago. I apologize.
Okay.
I believe we discuss some witnesses, and I think he had some input even into my closing argument. But again, this was so long ago.
Do you recall if he assisted prepping any witnesses or helping with cross-examinations at all?
No, I did all the cross-examinations.
Who participated in depositions?
Mainly me.
Do you recall if Mr. Masor went to any of them?
I do not recall.
Now, this case was initially...
All right, Seaver's old attorney on the stand there. I guess the co-counsel has passed away, so he is he's testifying at this hearing, and again, Mark Seaver's trying to get himself off of Florida's death row. We'll continue to monitor this one. We'll be going back in and out. This is going to last a few days. Donna Adelson getting sentenced today officially. Is she going to speak? That's at 3 o'clock, or Julia Janae in Florida for that one in Tallahassee. Let's get a break here. We'll have more from the Seaver's attempt to get off of death row when we return. Stay with us.
Donna Adelson was part of a conspiracy to kill her former son-in-law, Dan Markell.
He's not going to survive.
Oh my God.
Dan saw Donna as dangerous.
She's the matriarch mastermind.
She's just being a parent, not a killer.
Victim to Verdict with Ted Rollins, season finale, Saturday night at 8 Eastern and Pacific. And during the finale, don't miss an exclusive preview for the new season of Interview with a Killer, only on Court TV.
Welcome back to Court TV Live. Good to be with you on this Monday. I'm Ted Rollins. We're going to head back to Florida for more of the Seavers hearing, which is supposed to last multiple days in a bit. But here's a quick look at some of the other cases we're tracking today on this Columbus Day in Florida. Matriarch mastermind Donna Adelson is set to be sentenced later this afternoon. She was found guilty earlier this year, of course, of orchestrating the murder for hire plot to kill her daughter's ex-husband, Dan Markell. In Wisconsin, the state's case continues for a teenager accused of killing a young woman who got caught in his crossfire while taking the trash out. On the stand now, another shooter and co-defendant in this case. That's Wisconsin versus Larry. In Ohio, the fate of Bionca Ellis will soon be in the jurors' hands at closing arguments expected to begin tomorrow. Court is dark there today. In Florida, the state expected to rest tomorrow in the toxic relationship murder trial. And then we'll see if Daisy Link is going to get up and tell her story. Will she take the stand? We'll find out tomorrow. They are also dark today. We'll keep an eye on all of this, and we'll be heading to the Adelson sentencing. Our Julia Janae is there in Tallahassee, and will be field anchoring and taking us through that again, 3 o'clock Eastern time for that. Right now, let's head back to more of this hearing for Mark Sievers, the hired hammer killing. Right now, we're hearing from his old attorney, his defense attorney, who Sievers claims failed him during his trial.
Now, this case was initially tried with Mr. Rogers' case.
Yes.
How was that working relationship with Mr. Rogers' team?
I'd like to think we had a good working relationship. Ms. Fitzgeorge, who was the lead attorney on Mr. Rogers' team, she was actually my supervisor while I was at the public defender's office. And you know, she's certainly someone with whom I respect and have great admiration for, and she was very helpful, knowing that yes, this was my first capital case, giving me advice, and I will be eternally grateful for her assistance.
You said she would give you some advice. Do you recall if there was a specific area you would reach out to her about?
Just about. I know she gave me advice. You know, you should probably go to this CLE. I think it was might have been Death is Different. But you know, I certainly followed her lead in depositions. And we had, over those years, we had a lot of conversations about this case.
Would you find Ms. Fitzgeorge took the lead in depositions a majority of the time?
The majority of the time, yes.
Okay. Do you recall if there were any conversations, if Mr. Rogers had any helpful, any information that could either help or hurt Mr. Sievers?
I do not recall.
Do you recall if there were any shared theories?
Oh, yes. Yes, we definitely had some shared theories. But our cases were very different.
How so?
So, Mr. Sievers' case was more about the conspiracy, about the prepaid phones, about the communication with Mr. Wright versus Ms. Fitzgeorge's case, which had a lot more to do with forensic evidence, crime scene, the jumpsuits, where the jumpsuits were deposited, the cell phone tracking records. You know, because our clients were 1,000 miles away when the murder occurred.
You just kind of made a line between kind of like forensics with Mr. Rogers' cases and not forensics with Mr. Sievers' case.
Yes.
Did you find forensics more so irrelevant for Mr. Sievers?
Yes and no. So, in the strictest legal sense, it was irrelevant what actually happened in the house. If we look at 401 and 403, being that it was my opinion, and judge disagreed with me, that the prejudicial value of most of the forensic evidence outweighed the probative value. I mean, this was horrific, this was gory, and our case really just depended on, whether there was a conspiracy and whether a series of phone calls had happened. We didn't need the records of how the tow truck towed the car from wherever the enterprise was down to Florida. That wasn't really relevant. How the jumpsuit ended up at the side of the road, that wasn't really relevant. However, I understand that they were co-defendants. This was all evidence in the same set of charges, and so in that respect, yes. Although, I personally believe that the prejudicial value outweighed the probative value, and therefore, a lot of this evidence I felt really put Mr. Sievers in the position of having the jury judge him more as a person rather than for what he did. And, one of the jury instructions is you should not decide this case if you were angry at anyone or feel sorry for anyone. And I believe a lot of the evidence that came in did exactly that. And so it was our position that in Mr. Sievers' case in chief, a lot of the evidence was kind of extraneous, but it got in.
All right, let's get a break. Before we do, let's check in with Matthew Mangino. He's in Pittsburgh, Pennsylvania, and also with us, law enforcement expert, jury consultant Sonny Slaughter. This case, I remember it well. The problem for Sievers always was how disgusting this murder of this doctor was and the way it was orchestrated. These guys showed up, and Sievers was conveniently out of town. When you have a guy on death row, he's obviously going to fight the rest of his life, Matthew, to get off of death row, and that's what we're seeing here. Ineffective assistance of counsel is one of the themes that we'll see. What are his realistic chances?
Well, it's very difficult to get a conviction overturned through post-conviction relief. This is the portion of the case where you can attack your attorney for ineffective assistance of counsel. You can't raise that issue on a direct appeal. It's only in a post-conviction action that you can do that. And so, the United States Supreme Court in a case, Strickland versus Washington, made it very clear that you have to show, number one, that your attorney was ineffective in some way in representing you, but number two, that ineffectiveness, had there been a better attorney, so to speak, the result may have been different, and that's a very difficult hurdle to get over.
There's Siever getting his handcuff off. I don't know, Sonny, this might be a case you don't remember, but I remember it well. He took notes like no other defendant has ever taken notes, but he's just always scribbling notes, and he's apparently back at it again today, as they say. This case, though, was, Sonny, from a law enforcement standpoint, difficult to solve. You had a dead doctor. He was originally, he's out of town, and he played the part. Oh my gosh, my poor wife, all of that. But life insurance and then communications. This was a classic example of unraveling and unpeeling this onion, and it exposed these two numbskulls that carried it out, and boy, it was a direct line to the husband. What you remember of this case, the way law enforcement was able to unravel it?
It's great to see Michael today, and great to see you, Ted. These cases with this murder for hire, first of all, they're always very personal for me because something happened in my family from a murder for hire. But law enforcement has to meticulously put together the timeline, the time frame, and even though he was out of town, I believe that they were able to show that, one, he was the benefactor of all of of her death, and at the other two were just hired, and their conversations, and you know, people always forget that law enforcement can really go back and tie in those conversations. When you start calling, you're calling all the time. When you stop calling right after the death, then things get, you know, really interesting, and how that relates. So I just think that the defense counsel is doing, and that Severs is doing what he has to do to get himself out of the conviction and out of jail. I don't think it's going to be successful, because I think law enforcement had a really solid investigative process when they were able to tie him in. And it didn't take as long as it could have, which in some cases is often years. It only took like 6 months or so before they tied him in and arrested him. So I think he was good for the murder then, he's good for the murder now, and I don't think he's going to get off, but he's doing what he needs to do.
Yeah, he was a classic burner phoner guy. You know, the criminal mind is like, well, I'll turn my phone off during the murder. Okay, that's a red flag. And then, or I'll get a burner phone. That's another one. And in this one, it was the burner. He'd never had one before, and there he is buying one at, I think, at Walmart. Jury didn't buy anything, he said. Let's get a break. When we come back, we'll have more Sievert also talk about Donna Adelson. She's going to be sentenced today, 3 o'clock Eastern time. And we've got a couple other cases brewing on this Columbus Day. Stay with us. Welcome back to Court TV Live. Before we head back for more of this Sievers hearing, an update out of Indianapolis, Indiana, where former quarterback Mark Sanchez has now been released from custody a week after his arrest. The Fox Sports analyst was stabbed last week, of course, after police say he attacked a truck driver in an alley next to his hotel room, or his hotel. Sanchez faces a battery charge, several misdemeanors for what prosecutors say was a fight over parking. Sanchez didn't want the guy parking doing his job. Sanchez was hospitalized with stab wounds, but he was the one that got arrested. He was stabbed in the upper right torso. He was booked and released from custody Sunday. The truck driver also taken to the hospital for his injuries. He says he was permanently disfigured in the attack. It looked pretty rough there. Sanchez's ex, Bobby T., who is also the mother of his 8-year-old son, recently weighed in on the attack as well, posting to Instagram in part saying, "Now that everything is out in the open, my focus hasn't changed. I've always been concerned for her son's well-being and for what he is exposed to. Sadly, none of this is surprising to me." We'll keep you updated on that as developments continue, but he is out of the hospital, Mark Sanchez. Let's head back to Florida. We've been watching this evidentiary hearing. This is Mark Sievers saying, "I want off of death row." Back in 2019, he was convicted of first-degree murder in the brutal death of his wife, Teresa. Now he's back in court fighting to have that conviction overturned. He wants the death sentence overturned. He doesn't want to die in Florida by the state. So let's go back in and hear from Sievers' attorney, who is now on the witness stand, Michael Mummert.
Kind of going off of that line of thinking, did you find that experts had a role in this case? Or did you find a role for experts in this case?
Yes, Ms. Lyons was our expert witness who testified about she was the Sievers estate planning attorney, you know, she actually was very helpful, and that the jury found that the murder was not committed for pecuniary gain. And so, yes, Ms. Lyons was invaluable in our defense. But you know, as far as our theory of defense, she was the expert who was the most pertinent to our side of the case.
Do you recall if you consulted with any other experts?
Yes. I know we consulted with, I believe it was Dr. Underwood. Dr. Underwood met with Mark on a couple occasions, ran a litany of psychological tests. I believe it was MMPI. There were other cases where he was looking for essentially mitigation evidence.
Okay. So that would have been a mitigation.
That would have been a mitigation expert. I don't believe Mr. Underwood ever generated a written report. I'm unsure of that, but I know he was deposed, and the state had an opportunity to kind of get his findings.
Do you recall any experts as it more so relates to guilt phase?
Other than Ms. Lyons, I don't.
Do you recall if you spoke to a crime scene expert?
I do not.
Would the name J.D. Thomas sound familiar?
It does. And again, I may have spoken to Mr. Thomas, but again, I don't recall that conversation with any distinct recollection.
Okay. Moving forward to kind of the pretrial portion, were you aware of the media attention this case garnered?
Yes.
Did you follow the news?
No, it followed me. I would get people, "Oh, I saw you on the news." Great. You know, just like I'm sure I'm going to hear about this tonight and tomorrow.
Did you ever consider filing a motion to change venue?
We did. We did.
Was
and
one ultimately filed?
No.
Why not?
Because ultimately I made that decision. And so when you change venue, you don't get a say to where the venue actually lands. So we could have ended up in Collier, Polk County, Hendry, Glades. We didn't really get a choice. And when you don't get a choice, again, you're dealing with the unknown. And had we ended up in, say, Glades County, this would have been everywhere. We could not have gotten a jury in a Glades County. Had we ended up in Collier County, we would have actually ended up with a more conservative demographic. And so we had these conversations, and ultimately I made a strategic decision to not change venue.
Okay. Do you recall if you researched or considered filing any other motions pre-trial?
I filed a bunch of motions. I filed motions in limine. I mean, can you be a little more specific, please?
I'll come back to that question. Hey, one moment here.
Yes, ma'am.
Just want to fast forward to Mr. Curtis Wainwright. What was Mr. Wright's role in this case?
So it is my opinion that Mr. Wright was the only person swinging the hammer, that he was the murderer. And that was based on the some of the crescent-shaped bruises and lacerations on Miss Seaver's skull were all the same size. So he was also the government's star witness, and he got an advantageous plea deal in exchange for his testimony.
And what was your...
All right, let's get a break. We'll have more of this hearing. Mark Seaver's trying to get himself off of Florida's death row. Stay with us.
The defendant is guilty of first-degree murder.
Convicted for the murder of her former son-in-law. How long will the matriarch mastermind spend in prison? Was it worth it? The sentencing of Donna Adelson, today at 3 on Court TV.
Donna Adelson wasn't a regular mother.
She's the matriarch mastermind.
She's just being a parent, not a killer.
Victim to Verdict with Ted Rollins. Season finale, Saturday night at 8 Eastern and Pacific.
Only on Court TV.
Welcome back. A Florida man is in court this morning fighting to have his conviction and death sentence overturned. Back in 2019, a jury convicted Mark Sievers in the brutal murder of his wife, Teresa. Her body was found beaten to death with a hammer in the family's Bonita Springs home nearly a decade ago. Now, Mark Sievers' defense team says that newly discovered evidence not presented at trial undermines the confidence of the verdict and is asking the judge to vacate that death sentence. Well, this is the same judge that sat through that trial. Let's head back into the courtroom. We've been listening to testimony from Mark Sievers' original attorney, Michael Mummert.
And what was your plan for dealing with Mr. Wright or putting forth your theory of his involvement?
Well, my theory was basically that he was willing to lie in exchange for the best possible outcome. And when you look at his testimony, first time the police talked to him, he said, I wasn't there. And the next time, okay, I was there, but I didn't go in the house. And then it was, okay, I was in the house, but I wasn't in the room. And then it was okay, I was in the room, but I didn't swing the hammer. And then it was, okay, I was in the room, and I swung the hammer maybe once or twice, but that was it. And so we had multiple inconsistencies, and there's no way to reconcile those inconsistencies to say that it was mistaken. No, these were lies. These were lies. And even, I believe, in his proffer, Mr. Hunter said, you are not being truthful. So essentially, one of the jury instructions is, again, you should consider the truthfulness of the witness's statement. Specifically looking at, did the witness ever make a prior statement that was inconsistent? And in this case, Mr. Wright absolutely did. And it was very clear that he made these prior inconsistent statements, these lies, in exchange for an advantageous plea deal. And that was not rebutted.
Do you recall if you considered consulting with an expert to advance your theory?
That he lied, that it was recorded. I mean, there was no need for an expert. This was, he gave 5 separate inconsistent statements that one of them could not be true if the other one was. There is no need for an expert. These were lies. Everyone knew they were lies, and yet I cannot see how an expert would say, oh yes, when he says he was not in the house, and they said, oh, I hit Dr. Sievers with a hammer. There's no way for both of those statements to be true.
Okay. Did you have any desire to speak with Mr. Rogers?
I don't know. So I learned after the trial that Mr. Rogers had changed his story. I had learned after the trial that Ms. Shoemaker had changed her story. And obviously that prior to trial, that would have been helpful, but I hadn't. Yes, my short answer is yes. I would have liked to have spoken to Mr. Rogers. However, he was represented by counsel, and in order to speak to him, I would have to get Ms. Fitzgeorge to agree to allow me to.
Did you make any attempts to do so?
I did not. I did not, because I know that she, her client was facing the death penalty the same way as my client, and Ms. Fitzgeorge is a fierce advocate for her clients.
And then lastly, do you recall how records were shared in this case between your office and?
Okay, so we originally, when this case was going on, well, I'll fast forward. Currently, records are shared from the state to defense. There's kind of a portal, and you download it. If it's a bigger file, then there's a Axon evidence that you can download these files, and if it's really big, you bring a big flash drive to the state and they give it to you. In this case, we got CDs. It was long enough ago where people were still using CDs.
Okay, this is going to be a multi-day hearing, and we'll be monitoring it here at Court TV to see if Mark Sievers can be successful. There has been some movement with the other defendants in this case, and even during trial, you knew that the one guy was a liar. We're going to get a break. We're going to switch gears, talk a little bit about Donna Adelson, who is going to be in a Tallahassee courtroom later today at 3 o'clock Eastern Time. Matthew Mangino, Sonny Slaughter still with us. What do we expect here from Mama Donna? Sonny, you first. Do you think that she is going to want to say something? She'll have an opportunity. It's a sentencing hearing to address the court. Will she be able to keep quiet, or what are your thoughts as we get ready for this 3 o'clock hearing?
I think she's going to want to say something. I don't think she is going to say anything because she is going to be focused on her appeal. I look forward to a judge sentencing her to life. And for her, that's how she's going to say something like she did the last time. You know, that little fake cry and outburst, that's going to be her.
Yeah, it's an iconic reaction from a defendant of when she said, "Oh my God, what?" Like, I couldn't believe it, Matthew. What's your take? She is 75. Her appeal won't come through likely till she's dead, just the way the slow wheels of justice move. We saw it in Ferris. She got up there, same scenario, and just went off. Any chance that Donna says something, in your opinion, Matthew?
Well, no, Ted, I don't think she says anything. If she does, frankly, you're going to see post-conviction relief actions filed for ineffective assistance of counsel. I mean, if she wants to appeal her case and she wants to show that she's not responsible for this killing, she can't say anything today. Because anything she says could be used against her ultimately in a new trial. So I would assume she's not going to say anything today.
We'll see if Dan Markel's relatives will be there. We know his mother and father addressed the court during the after the conviction. The judge allowed them to do that. They live in Canada. Not sure if they'll make the trip this time around. Well, we shall see. Will Donna have anybody? Will Harvey be there? Wendy? Maybe. We'll find out. 3 o'clock. Thank you both for your time on this Monday. We'll get a break. More Mark Sievers. Plus, we're going to check in with Julia Janae from Tallahassee.
888-8558. That's 1-800-622-8558. So call now.
Welcome back to Court TV Live. I'm Ted Rollins. Good to be with you on this Monday. We're going to begin the hour in Florida where matriarch mastermind Donna Adelson is set to be sentenced later today. Adelson, of course, was found guilty earlier this year of orchestrating a murder for hire plot to kill her daughter's ex-husband, Dan Markell, FSU law professor. He was gunned down in his vehicle inside his garage back in 2014. This is all in Tallahassee. Adelson is now the 5th person to be convicted in the death of Dan Markell. Adelson's son Charlie was found guilty in 2023, along with the 2 hitmen and the woman in the middle, Catherine Magbanawah, who was Charlie's girlfriend and also shared 2 children with Sigfredo Garcia, one of the hitmen. Before we bring in Court TV's Julia Janae, she's there in Tallahassee, let's take a closer look at the trial for Donna Adelson.
Who in Dan Markell's life would hate him enough to hire a professional killer?
They put her at the top of this pyramid behind Danny being killed.
Did you say my parents have more reason to dislike Danny than almost anyone else?
At that point, I was sitting with law enforcement for 6 hours and had just been told that Danny had been shot.
She called him a lot of bad names.
Yes.
She said ugly things about him.
Yes.
But not one single time did she ever suggest that Danny deserved to be harmed, did she?
Never.
She had said, you know, I don't know and I don't care. It doesn't concern me.
Was that out of character for her to not be curious?
Yeah, I mean, it was an unsolved murder of my former brother-in-law.
She's the matriarch. She's the matriarch mastermind. They don't have evidence of that.
Did we have it right? Were you the middleman between the shooter and Charlie Adelson?
Yes, ma'am.
He did tell you that his mother washed the money.
Yes, ma'am.
We took an undercover agent.
Excuse me, Mrs. Adelson? How you doing? Just want to give you this.
And who is the first person that the defendant calls?
Charlie Adelson.
As it relates to your right to remain silent and your right to testify, what is your decision?
This time I don't want to testify.
The undercover approaches Donna and hands her a piece of paper. When Charlie asked Donna, does it involve me or other people? Well, probably both of us.
She called Danny a major. She called him a royal, a piece of. You call somebody some bad names and that means you wanted him dead?
Catherine Magbanawah admits she was in a plot to kill Dan Markell, and she got 44 checks and they were all signed by this woman.
They cannot prove she had him killed. At the time that he was killed, she had paid anybody or asked anybody to do it.
We, the jury, find the defendant is guilty of first-degree murder. Mrs. Adelson, control yourself.
Will Mrs. Adelson control herself today? We'll find out. 3 o'clock Eastern Time is when this hearing begins. Let's head out to Tallahassee. And there she is, Court TV anchor Julia Janae. She'll be there. She was there for the trial, be there for the sentencing. Let's talk about the choices that Judge Stephen Everett has and the limitations, I guess, with the convictions here. That's where we'll begin in terms of what we can expect from the hearing today.
Good afternoon, Ted. Good to see you. That's right, inside of the Leon County Courthouse. That's right behind me. We are going to be hearing that sentencing starting up, and it's going to start up at around 3 p.m. All those parties are going to gather. The Court TV cameras are getting set up right now. And as far as the sentencing range, there's not a lot of wiggle room on that top charge, the first-degree murder charge that Donna Adelson was convicted of just a little over a month ago. You see her there. We saw her at the verdict, her reaction to everything. She was also found guilty of solicitation and conspiracy, so there may be some wiggle room in those sentencings and whether or not they're going to stack in terms of consecutive or if they are going to be concurrent. But that top charge carries a life in prison sentencing. So that's what we're expecting to hear from Judge Everett today on that. And the big question really is whether or not this time around Donna Adelson is going to speak. And we understand from her attorney, Jackie Fulford, that she is likely going to speak. Remember, Ted, she struggled with whether or not she was going to testify, and it took several rounds before she finally made her decision. And she didn't seem to be happy with it. It even came up in her motion for a new trial that she said she didn't get enough time to make that decision, so she'll have an opportunity now. But what we can expect inside of this courtroom is that it's going to be packed again with a lot of those supporters of Dan Markel. I mean, they have been here day in and day out of trial after trial. His parents, Ruth and Phil Markel, his sister Shelley, they were here for the trial. We're not expecting them to be live here inside of the courtroom here in Tallahassee. They are in Canada. We expect that they are going to be appearing via Zoom to be able to listen and react if they want. But remember, back when she was convicted, even though the sentencing was going to be put to a different date, they did have the opportunity to immediately give those victim impact statements. Here's just a clip from Dan Markel's father, Phil.
She has harmed forever the people she claims to have loved. In the Jewish custom, we have an expression to always wish others to live to 120 years of age. For Donna, I wish her to live to 120, alone in her jail cell. I wish that every day of her remaining days, she thinks about the harm she has caused to so many, especially those two boys she claims to have loved so much. For these reasons, Your Honor, I ask the court sentence Donna Adelson to the maximum possible sentence. And my only short question to Donna, was it worth it?
Those were such powerful statements inside of the courtroom. Just listening to his parents really seemed to unload this pain that they've been feeling during that moment. It was really a longer victim impact statement than we'd heard from them in the previous trials. So Ted, today we could hear more victim impact statements like that one. And we also know that at the end of all of this, Donna Adelson, she's in jail right now, but she's eventually, after she gets this sentence, going to be transferred to the Department of Corrections here in Florida.
Do we think anyone will be there on behalf of Donna? Harvey was there during the trial. What have you learned, or what is our feeling going into today?
Well, you know, during the trial, we understood that he had set up, Harvey, her husband, had set up an apartment here in Tallahassee, so moved from Miami to be here closer to his wife. So I think it's likely that he'll be inside of the courtroom today. And according to her attorneys, there are going to potentially be family and friends of Donna Adelson who will be speaking. And we saw some family and friends, well, friends for sure, inside of this courtroom. We saw her children testify, but they didn't stick around in the gallery. But several of her friends were in the gallery with Harvey on that verdict day, and we heard from some friends. Here's one of them, Richard Chagrin. He actually testified and tried to help the defense in terms of that one-way ticket to Vietnam that the prosecution said was evidence that she knew she was guilty.
Were you asked to assist them in any way on November 7th of 2023?
Yes.
And specifically, what were you asked to do?
Initially, I helped Donna with the visa.
When you sat down to assist with the reservations, what did you discover?
The ironic thing was that the round trip was a fraction more than one way, and I suggested, since you don't know when you're coming back until sometime in January, you know, book a one-way. And I remember commenting to Harvey, I said, I'd be willing to bet it's cheaper to fly from Vietnam to the United States than it is from the United States to Vietnam.
And again, I mentioned her children, Wendy Adelson, of course, Charlie Adelson behind bars. He won't be here, but her son, Rob Adelson, I don't expect them to be in the gallery. Wendy has not attended any of the other cases after she testifies. She has immediately left the Tallahassee area, so don't anticipate that she will be here for her mother's sentencing.
Yeah, that would be something else if she showed up. Is there a possibility of a deal at this point, or is that long gone?
You know, there were rumors, right, during the pretrial portion of this case of whether or not Donna would be flipping on Wendy, whether she would offer testimony and help prosecutors go after her daughter. No one ever confirmed that on the record beyond the defense saying they didn't have a firm offer from the prosecution. So that left the door open in my mind that there maybe was something that was floated, nothing in writing, nothing confirmed. But we know that though she has been convicted, there's another person in this whole case who's been convicted and is hoping for a deal. That's Catherine McVanoa. So she is hoping that there's going to be a way that she can be resentenced and let out sooner than her life in prison sentence that she received in this case, because she changed her story after she was convicted. So I think there is a possibility, Ted, that if she was interested in that, Donna Adelson could approach the prosecution, but nothing that we have heard says that she's going to be doing anything other than looking towards her appeal.
We'll see. This case, you never know what is next. What we do know is that she'll be in court at 3 o'clock, and that Julia will be hosting the 2 p.m. ramp-up hour as we get ready for this sentencing hearing. Julia, thank you. We'll check in with you again next hour. Let's bring in our guest for the hour from Cherry Hill, New Jersey, criminal defense attorney, former prosecutor David Gelman. David, what do you think? What's your take on her? It sounds like Julia has heard that through the attorneys that Donna may want to say something to the world here, and it'd be her last chance before she's shipped off to the Department of Corrections. She didn't testify, but she's also 75. I mean, realistically, this could be it for her to get out her whatever version of the story is.
Look, does she want to say something? Of course she does. She probably wants to talk for hours at the time to the judge. But will she? That's a real question. I'm sure her attorneys are telling her, Donna, please, whatever you do, do not do this, because all this will do is affect your appeal. That's your wishes. So I don't see her actually testifying, although, she's going to hem and haw until, whatever it is, until she can actually do it. But I don't see her actually being able to testify. I just don't see her attorneys allowing it at this point.
Sounds like she's got some friends that have stood by her. Her reaction after the verdict, it was almost like she was doing it on some weird level for that friend group that she still kept. That, because it was what? I can't believe this. Even though she sat through the same trial we watched. What dynamic does that do? And given the sentencing limitations for Judge Everett, I mean, it doesn't matter who gets up and speaks. Really, it's not going to drop her sentence. And again, her age is significant. 75 years old. She's not getting out.
Well, number one, Ted, I love your expression of Donna when you do that, especially last segment. It was perfect. And I hope Donna does that again, although, her attorneys are probably going to tell her, try to stay a little more calm this time. But you're exactly right. The judge is tied. His hands are tied. There's only so much he can do. So it's a life in prison, at the minimum for her. And again, you're right, 75 years old. She's going to have that appeal, but like you said in the previous segment, her appeal, she'll be dead before they actually hear it. So I don't really see her having much of a shot of anything other than she's going to spend the rest of her days in jail.
Wendy, Harvey, is Donna the last one, or is Georgia Kappelman, the prosecutor, going to continue on this journey and possibly indict others, specifically Wendy and maybe Harvey? What's your thought?
Harvey, I don't think so. It doesn't really seem like he had any involvement. But Wendy, it's a good idea that she's not going to that court today. We don't think she's going to be at that court because she could be arrested any day now. There's been a lot of evidence that from individuals that she is involved. So I could definitely see the shoe dropping on Wendy, that she's probably going to be the next one to face some charges.
Yeah, and this trial was different in that there was a lot of Wendy talk. You go back to Charlie's trial, there was a lot of Donna talk. And if you kind of take that progression and then Georgia Kappelman's words afterwards saying, stay tuned when asked about Wendy, it's definitely an option. Stay put. David, we're going to take a break, and when we come back, switch gears to Ohio. Closing arguments expected to begin tomorrow for a woman accused of fatally stabbing a 3-year-old boy in the grocery store parking lot. Court TV's Matt Johnson is going to catch us up when we return.
The
the defendant is guilty of first-degree murder.
Convicted for the murder of her former son-in-law. How long will the matriarch mastermind spend in prison?
Was it worth it?
The sentencing of Donna Adelson, today at 3 on Court TV.
Donna Adelson wasn't a regular mother.
She's the matriarch mastermind.
She's just being a parent, not a killer.
Victim to Verdict with Ted Rollins. Season finale, Saturday night at 8 Eastern and Pacific.
Only on Court TV.
Welcome back to Court TV Live. We're going to turn our attention to Ohio, where a woman is on trial for fatally stabbing a toddler last year, Bionca Ellis, accused of stabbing 3-year-old Julian Wood to death at a parking lot grocery store last June. The boy's mother also stabbed. She survived. She took the stand during this case. Surveillance video taken inside the grocery store shows Margot and Julian Wood. They're in the they have the cart there, and you see Ellis. After they pass by, Ellis just turns and is focused in on them. She would follow them out and stabbed them both, including a fatal wound given to little Julian. Court is dark today because of Columbus, but we're expecting closing arguments to begin tomorrow. Before we discuss, here is Court TV anchor Julie Grant with the latest on this case against Bionca Ellis.
I'm at North Olmsted, Ohio, Giant Eagle. Someone just stabbed a kid and a lady in the parking lot.
Chaos breaks out in the parking lot of a Giant Eagle grocery store just outside of Cleveland, Ohio on June 3rd, 2024.
There was a child. He's bleeding all over the place. We're at North Olmsted Giant Eagle.
Margot Wood was shopping with her 3-year-old son, Julian, when they were attacked by a knife-wielding stranger.
The young child suffered 2 stab wounds, one to the face and one to the back, and then she suffered one to her shoulder area.
Julian died of his injuries, but his mother, Margot, survived.
It was hard to go help the kid. He's in the first couple aisles.
Where's your cuffs? Get cuffs? Who's got cuffs?
33-year-old Bionca Ellis was arrested on the edge of the parking lot where the stabbings happened. A long blade knife was found on the ground near where she was cuffed.
Did she say anything?
No, I didn't hear anything. I had my windows down. I didn't hear anything. All I heard was just screaming, and the lady grabbed her child up out the cart, and that's when it fell over, and they collapsed over here, and the lady just continued to walk off.
Police say Bionca Ellis stole a knife from a nearby thrift store. Surveillance video shows Ellis walking into the grocery store with the knife in plain view.
It was very, very upsetting that someone would do that to a child and their mother.
As Margot Wood swerved her grocery cart to avoid running into Bionca Ellis, Ellis turned around to follow Margot and Julian out of the store, the whole time swinging the knife by her side.
As a mother, I cannot even begin to fathom the sense of loss that this family is going through.
Ellis is facing multiple charges, including murder, attempted murder, and felonious assault.
Have you received and read your indictment?
I don't know.
You don't know if you've received it?
She was found competent to stand trial after her defense team requested a mental health evaluation. This after her behavior in the courtroom raised questions about her ability to assist in her own defense. For the family of Julian Wood, they'll never get over the loss of their child.
She took everything from us. There's nothing that could ever replace my son.
Court TV Crime and Justice correspondent Matt Johnson joins us live with the latest in this trial. And, they're dark today. We have that imposed delay of showing testimony, so we're actually going to catch some of that later this hour. But fill us in.
Yeah, this is probably the most critical part of the trial for this jury. The jury hearing what could be the most important testimony of the entire case, because tomorrow, being day 6, we are right in the center of the battle of the experts. And that's what this comes down to, right? So far, the Ohio jury has heard from 2 forensic psychiatrists, actually 3, who evaluated the defendant, including Dr. Sarah West for the defense and Dr. Stephen Knopfsinger for the state. Let's listen to both.
It's my opinion with reasonable medical certainty, however, that the defendant did not have a severe mental disease or defect at the time of the June 3rd, 2024 offense that caused her to not know the wrongfulness of the offenses. So despite having schizophrenia, it did not cause her to not know the wrongfulness of the offenses.
After that, can you identify what your opinion is?
So ultimately, to summarize, it's my opinion with reasonable medical certainty that Ms. Ellis suffers from a severe mental disease, namely schizophrenia, and was experiencing symptoms at that time related to this illness that caused her to not know what she was doing was wrong.
And really, it comes down to that, right? Because Ellis is claiming not guilty by reason of insanity. The jury is going to have to decide who they believe of these experts as we're in this battle of the experts. And if she understood the wrongfulness of her actions as she was committing this unthinkable crime, that's what they're really deciding. Because the defense has admitted, you know, that she did it. Yeah, there's no argument there.
Yeah, and the video tells it. The jury, no, it's funny. You're right. It absolutely comes down to this battle of the experts. And in cases, we have versions of this, but in this case, it truly is. These experts, that's what the jury has to hone in on.
And so this would be a really good day for our courties to look back at some of the other testimony that we have online and with my updates throughout the day as we prepare for day 6, which is tomorrow, because, you know, you have all of these lay witnesses, all of these first responders, and they go through the graphic nature of the crime, but then, you know, the state saved their expert as the rebuttal witness to the defense 2 experts, and that's what we're in right now.
Yep. And then next, we're looking forward to, I guess, closings?
Yeah, and the cross-examination of this witness. So that's first out the gate tomorrow, day 6, and then it's going to be closing arguments. Something that we could see similar to all the statements that were made in openings. We often see that. So let's play a bit of the openings together.
And it is true that whatever's going on in her mind, whatever's going on with her mental illness, the evidence will show that she got behind this wood and her child, Julian, and she followed her. And she doesn't run away. She walks away. She still has a knife in hand at the time that the police confronts her.
And she's got the 12-inch butcher knife. And she has it right by her side. And she's walking. And she's walking. And she follows them all the way out of the store. And you will see that she is walking in tandem with them. She stops, waits for them to catch up, and follows them completely out of the store.
I think that that's what we can expect, right? A tale of how to look at the evidence and what was she thinking at the time when she's doing those actions, right?
Yeah.
So that's probably what we're going to see in closings. And also this state and the defense experts and how to interpret that, or how the attorneys want the jury to look at that.
It's interesting, those 2 clips, basically the attorneys are saying the exact same thing. But
it's how you interpret it.
Yes. Oh, if you look at it from our standpoint, it's this. And then, so, to your point, the jury's got a lot to think about.
And also, here's another thing to watch for with this case. You were talking about it. There was a court order where we had to delay testimony in the case. We don't think that that's going to be the case tomorrow when we're in closings. We're going to be able to carry those live, we believe, and then also, of course, the verdict.
Yeah, which would be great. Matt, thank you. We are going to get a break in here. When we come back, we're actually going to play some of that on-air testimony from the defense's final witness, a forensic psychiatrist who evaluated Ellis. That is next. Stay with us. Welcome back to Court TV Live. I'm Ted Rowlands. Good to be with you. We're going to head back to Ohio now. Court is dark for Columbus State today in the Toddler Stabbed murder trial for Bionca Ellis. Ellis faces 10 felony charges, including murder, in the June 2024 stabbing death of Julian Wood, a 3-year-old boy. Authorities have said that they believe the boy and his mother were randomly targeted in this attack, which took place outside of a grocery store in a parking lot. Since there's no court today, we want to take the opportunity to show you some of the testimony you might have missed from the defense case. Let's go into the courtroom now and listen to the cross-examination of one of the 2 defense witnesses to take the stand, experts. This is Sarah West, a forensic psychiatrist.
And you've indicated that you've testified for primarily the defense, but in fact, you've also testified for the state.
Yes.
And that was in Portage County.
Yes.
All right. So, Mr. Mack started with Exhibit J, the competency. But we can all agree, Doctor, that Miss Ellis, when she was questioned about informed consent, at all times that she was questioned about that, to give that informed consent, she was able to understand everything you were talking about. You agree?
Yes.
Okay. And that was not only from the time she was in jail, but at the time she went to North Coast, to the time that Dr. Testa interviewed her, Dr. Vanderkar interviewed her, and then you interviewed her a month later. Is that fair?
Yes.
So Mr. Mack goes through State's Exhibit J. I don't know if you still have that up there.
Yes, ma'am.
You do? Okay. Which bears your name and your signature?
Yes.
Right? Well, before I go any further, what does Argent Apple stand for, ma'am?
That's my private LLC, sole proprietorship LLC.
All right. So that is, are those your offices that you provide these forensic scientific services?
Yes.
Okay. All right. So when you meet Miss Ellis for the first time, have you gotten all of her psychiatric records?
No, I had not.
Okay. So when you are doing competency, you have some limited knowledge. Is that fair?
Yes, I did not have her medical records.
And at that time, you are relying on what other folks have observed.
I am relying on my observations at the time when I meet with her.
At that time, but what I'm saying is you have some limited documentation from the jail, right?
Yes.
That you are reviewing. These are other people's interactions with her, other people's observations. You're looking at whether or not she's taken her medication or that she's refused it, right? You look at all that before you even begin yours. We haven't begun yours yet. When you first get there.
Are we referencing the competency report?
Yes, I'm just talking about competency right now.
I did not have access to a great deal of information. This was only 1 month after the events occurred, and mainly relied on my interview with her to assess her present mental state in order to offer an opinion on competency.
While there's a pause there, just, you okay? Okay, go ahead.
Thank you, Judge. So your mental, doctor, forgive me. I haven't numbered your pages because there's no page number, but we're going to go to your psychiatric history.
Yes.
Okay.
And is this the September report or the May report?
This is the July 8th, 2024.
July 8th, thank you.
This is the initial competency, right? And we're going to go to psychiatric history. And this is where you are conducting it, correct?
Yes.
All right. And you indicate in this report, upon inquiry of Ms. Ellis, she stated that she does not believe that she has experienced mental health issues. When asked about psychiatric diagnosis that she has been given, she said that she's been diagnosed with schizophrenia, schizoaffective disorder. So she is having a conversation with you.
Yes.
And she's indicating to you what she believes her diagnosis to be.
Yes, but you'll note the conflicting information between not having mental health issues and then being diagnosed with something.
No, I can appreciate that, but she's talking to you. It's not like there are auditory hallucinations at that time. She's having a conversation with you.
She is able to answer some of my questions.
Okay. And then you go on July 3rd of 2024, when you're there and talking to her with regards to the mental status examination, you indicate that she was initially forthcoming with a variety of disjointed, disorganized information. She became increasingly guarded throughout the interview, answering questions briefly and occasionally with the same response, even if it did not make sense. So where do we get now this guarded throughout the interview?
In that she started declining to respond to questions or would answer with the same response that wasn't necessarily related to the question that I asked.
And I believe Mr. Mack indicated that Mr. Johnson was there with you during the competency.
That's correct.
All right. Is that typical?
No.
All right. So why was it done in this case?
I was concerned about her mental status and seeing her alone.
Okay. And you were at the facility, correct?
Yes.
All right. And there are corrections officers there?
That's correct, but they do not typically stand in the room with me at the time of the evaluation for purposes of privacy.
Okay. All right. But they were there for the competency then?
Outside the room, yes.
The corrections officer, but the attorney was inside the room?
Mr. Johnson was inside the room with us, yes.
Okay. So you come up with the diagnostic impression of schizophrenia?
Yes.
Okay. And again, schizophrenia is what?
A psychotic disorder.
All right. And it's treated with medication?
Correct.
And it's fair to say that there are a lot of folks that have schizophrenia and function very well throughout their lives on medication?
Yes.
All right, we're going to bring in now David Gelman, former prosecutor and defense. This is just very difficult for jurors to get your head around. You've got competing experts here. What's your overall take in terms of the hurdle that the defense has to get over to get to that not guilty by reason of insanity?
You're right, Ted. It is a very difficult hurdle to get over. And when you have experts that are competing with each other, you know, it's almost like you're at a level playing field, really. And a lot of times it's like a tie. I like to think of it. You know, tie goes to the runner. That's how the analogy is in baseball, right? Juries don't want to hurt people. They don't want to do it. You know, they don't want to cause harm if they don't have to. So when you have two experts who are saying, you know, very similar things, but, you know, just different ways about it, I like the chances of a not guilty by reason of insanity. I really do. And this doctor, I think, has been coming off pretty well so far.
Interesting. Now, it is the defense burden, is it not, to get to that level, rather than saying, well, you know, it's beyond reasonable doubt, and the state's got all the burden. When you have this defense, the burden shifts.
That is exactly correct. The burden does shift. But again, the jury, they do not, in my opinion at least, and in my experience, they do not want to hurt people. They don't want to vote for guilty unless they have no choice, and they have to, and the evidence is overwhelming. And in this situation, I don't think they can see that. I think that the burden may be met here, and that's a pretty high burden to me, in my opinion.
Yeah, and it'll be the jurors will know on some level that a not guilty by reason of insanity does not mean that this defendant is let go. This person will be civilly committed and for many, many years, likely. How does that work? How do you play that? How do you make sure as a defense attorney they know that in your closing without stepping over a line?
That's a good question, and you got to say it over and over again. You got to just keep talking. Listen, we all know this happened. Nobody's saying this did not happen, but there's a reason for it. And this individual, our client, needs to get the help that she deserves. And the only way to do that is by not guilty by reason of insanity. You keep saying that over and over and over again. And just because she gets not guilty, that does not mean that she is not going to be spending most of her life, if not the rest of her life, in some type of facility.
All right, let's get a break. David, you're making me hungry sitting there. We'll get a break. When we come back, we'll have more from Ohio. Stay with us.
I'm going to ask you a lot of intensely personal questions. How do you explain it? The worst crime anyone can imagine. Do you feel like you took the fall for this murder? Tell me in your own words, what happened? Let's get started.
Interview with a Killer. New season premieres Saturday, October 25th. Only on Court TV.
head back to Ohio for more testimony in the murder trial for defendant Bionca Ellis. Prosecutors say that Ellis followed victims Margot Wood and Julian Wood, 3 years old, out of the grocery store in North Olmsted, Ohio, then attacked them in the parking lot. Julian suffered fatal wounds. Mom was injured but survived. Let's go back into this on-air testimony from the Ellis trial that was prohibited to run by the court until now. Here is the forensic psychiatrist, Dr. Sarah West. She's on cross.
Now, in your diagnosis, it says during the evaluation, her thoughts were disorganized and she appeared internally stimulated, as evidenced by her looking to the side and smiling to herself on occasion. So, is that an objective observation, doctor, or is that subjective? And how would you know it was an internal stimuli?
I would suggest that the objective portion of that was what I witnessed her doing subjectively. Through my experience, I believed that was related to internal stimulation.
But again, that was a subjective opinion, correct?
Yes, but based on my experience.
So then you determine her not to be incompetent, and then she is sent to North Coast. Fair?
I opined that she was not able to understand the nature and objectives of the proceedings against her and that she was unable to assist in her defense. Ultimately, it was the judge who adjudicated her incompetent, or rather sent her for a 20-day evaluation.
Okay.
So I offered an opinion and the judge based a decision on that.
So now let's talk about not guilty by reason of insanity, ma'am, right? You've testified, you've said in 5 trials, you've participated in 5 different cases, right?
Yes.
All right. And so I want you to tell this jury your methodology from the beginning to end, what you consider when you are making your determination.
So as we discussed, collateral information is important, historical data, previous mental health records are important. My interview with the individual, the evaluee, is important as well. And if I am conducting an insanity evaluation, I would do so at a time when the individual was relatively symptom-free and able to engage in logical conversation. I would also be interested in other legal history as well.
Okay. And that is all corroborative of determining the wrongfulness of one's actions.
I would use all that information to offer an opinion.
Correct. So all that opinion, all those items are necessary for you to create your opinion, correct?
Yes, they're all pieces of evidence that I would use.
All right. So self-reporting in and of itself is not enough. Would you agree with me?
Yes.
All right. And self-reporting, you would agree with me, should be recorded.
No, not necessarily.
Did you record your interactions in your evaluation for NGRI with Miss Ellis?
In the form of note-taking, but not audio-visual recording.
You did not record her?
That's correct.
Okay. Do you think that that's important to observe her answering your questions and using her own words so that could be related in your report?
I do quote her in my report, and those are based on my notes that I took during the interview.
My question is, do you think that that is important to record an individual and use it in making your determination?
No, I don't think it's necessary to record it.
Okay, why not?
Because I take notes.
Okay, because you take notes, but Don't you think it's a fairer representation of how the person reacts to your questions when you're asking the question, their gestures, their body language, their ability to understand, their ability not to understand? Don't you think that that is important?
I do, and I'm generally able to observe that during the course of the evaluation.
So you think that just your own subjective note-taking or objective note-taking is enough to demonstrate that?
I do, yes.
Okay, thank you. So in your report, you've indicated all the sources of information. And can you just list those for me, ma'am?
I had obviously an interview with Miss Ellis, my own report relating to her competency, a variety of competency assessments during her time at North Coast, the various police records in a variety of jurisdictions, and outpatient and hospital records from a variety of sources.
All right. And so with regards like to the North Olmsted Police Department records, photos, video footage, and date, do you opine on those in your report?
I don't believe I offer an opinion on them.
And those, some of those videos that were provided to you, you would agree with me, were of the day of the incident.
Yes.
And that is critical in making your determination for not guilty by reason of insanity.
Yes.
So those are objective things that you can look at and make your determination based on your training and your experience, right?
Yes.
All right, we're going to slip in a commercial break. We'll have more from Ohio when we return. Plus, we'll head back to Tallahassee. Our Julia Janae joins us before Donna is sentenced. Welcome back to Court TV Live. I'm Ted Rowlands. Good to be with you on this Monday, kicking off another busy week. We're going to begin the hour in Florida, where matriarch mastermind Donna Adelson is set to be sentenced later today, about 2 hours from now. Adelson was found guilty earlier this year of orchestrating the murder-for-hire plot to kill her daughter's ex-husband, FSU law professor Dan Markell. Markell was gunned down in his vehicle in his garage back in 2014 in Tallahassee. Adelson is now the 5th person to be convicted in the death of Dan Markell. Adelson's son Charlie was found guilty in 2023, along with the hitman and the woman in the middle, Catherine McBanois. They're all serving life sentences. Joining us live from Tallahassee, Court TV anchor Julia Janae. Julia is going to be hosting a special hour starting next hour as we ramp up to this sentencing hearing. Let's start with the latest we're hearing from the defense about who will be there supporting Donna today. What have you learned?
Yeah, Ted, this just hit the docket. The defense filed a notice to the court with a list of people who are offering their support. So this doesn't actually mean that they are going to be speaking inside of the courtroom, but they offered letters and emails. There were 7 different people who they filed letters. This is for Judge Everett to take into consideration. And here are a couple of them. This is a young lady, Dr. Ruth Rosenberg, who said that she's someone who emigrated from Israel when she was 12 years old, didn't understand the language, and she said Donna helped her. For several months in school, she said she sat by herself at lunchtime in the cafeteria, staring at Donna and her friends, when Donna walked over to the table and asked them to join her. And that kind gesture, she says to the judge, started a 62-plus year friendship. And she ended this letter by saying, the situation that Donna is in today is unimaginable. That is not the person I know and love. Now, another letter was actually submitted by someone who is a newer friend or relative of Donna Adelson. She is the grandmother of the child of Charlie, so they share a grandchild. And she said in her letter, Charlie Adelson surprised his mom with the news that he and my daughter Brianna were expecting a baby. It warmed my heart to watch Donna's genuine excitement and happiness. Our families began to spend time together, and I recall Donna being warm and welcoming. And as I got to know her more, there was no doubt in my mind that she was a loving and devoted wife, mother, and grandmother. And although Charlie and Brianna were no longer a couple beyond the baby's first year, we all remained close. She's been kind, thoughtful, loving, and generous. So interesting to hear from that side of Donna's family. Ted, that's someone we really haven't heard from throughout this trial, but we have heard about Charlie having a son and him really having a difficult time in prison because he understands he's missing out on his son's life. This was a son that was born long after the death of Dan Markell. Now, we do expect that there may be some people who talk inside of this courtroom, or these letters could be it. But we know we heard from friends during this trial who got into a little bit of Donna's character. Ann Cunningham is one of them. Take a listen.
Have you found her to be a hateful person?
Never.
Is she aggressive towards others?
Never.
Have you ever heard her threaten anyone?
Never.
Have you ever seen her harm anyone?
Never.
Have you ever heard her threaten to have somebody harmed?
No.
Did she ever make statements to you? Well, let me ask you this first. You were friends with her, obviously, when Wendy was going through her divorce.
Yes.
During that time period, through the divorce, and up to the time that Danny Markell was killed, you're aware that he was murdered?
Yes, I am.
Okay. At any time during that period, did she ever say she wanted to have Danny Markell killed?
Never.
Ever say she wanted him to be harmed?
Never.
Now, Donna Adelson should be making her way, if she's not already, in the courthouse behind me here in Leon County. And all we have gotten at this point from her attorneys is that it's likely she will be addressing the judge today, Ted.
Let's talk sentencing range. What are we expecting here?
Life in prison. That is what we're expecting the judge to say, because it is a mandatory sentence for that top charge of first-degree murder. But she also has been convicted of conspiracy and solicitation to commit murder, and those have more of a range, so he will have to decide on those. And you've got a defense that may be hoping that there is going to be on appeal a throwing out of perhaps that top charge. So that's when those lower charges could become important, if they are the ones that then become the top charge. We don't know, but we don't expect to hear from live in person Dan Markel's parents. They did speak right at the verdict. At the time where this verdict came down, you see Donna Adelson's reaction there, but they are in Canada, so they won't likely be here in person. They will be here via Zoom. But I do want to take a look back at Ruth Markel speaking after the verdict.
Prior to her arrest, Donna's recorded phone calls with Charlie reveal their lack of a moral compass or capacity for self-reflection. She blames external forces for her family's curse. They're outside of her, but she is the curse, and lashes out angrily at witnesses who took the brave step to testify. Her modus operandi has always been to run from Tallahassee and then to try to flee to Vietnam. For our family, there is no such prospect for escape. Danny's absence, and that leaves a hole at the center of our lives, no matter where we go.
No more running from Donna Adelson, Ted. And I also am going to be looking forward to what Judge Everett says. You know, he's been so measured throughout this trial. Sentencing is really the chance for the judge to then address the defendant. We don't always talk about that or anticipate it, but that's something that could be very interesting in this sentencing.
Yes, definitely. Judge Everett has been a treat watching him over the years with all of these trials, including this last one. The question that people have now is, of course, we always look forward. We always want to know what's next, what's on the horizon. What about charges on the, is this it for Georgia Kappelman and team, or is there another chapter?
Now, you know, we'll be asking her that question once this is over for sure. Now, what she said a little over a month ago was that we could stay tuned, that there may be something else to pay attention to, but she did not make any confirmation about whether or not there'll be charges. The big question is Wendy Adelson, the daughter of this defendant, the ex-wife of the victim, whether or not she's going to face charges. We don't expect her to be inside of this courtroom. She has not attended any portion of a trial that didn't involve her own testimony on the stand, which she had to under subpoena, and she was granted immunity from that, but she did not get immunity from charges at all. If they are able to get evidence against her that doesn't involve her testimony or something that was derived from her testimony, then charges could come. But we have been checking the docket often, Ted, and have not seen that any charges have been filed or a grand jury indictment has come down.
And that will, of course, be the topic of conversation once everything concludes today. Julia, we look forward to your coverage coming up next hour as we ramp up and get ready for the sentencing of Donna Adelson. Let's bring in our guest for the hour, joining us to discuss this case. There she is from Salt Lake City, Utah, criminal defense attorney Sky Lazaro. Sky, let's start with the next step. Do you think that this is it in terms of the Adelson saga, or do you think Wendy could be next?
I think a lot of that remains to be seen. She did testify under subpoena. This prosecution, though, has been relentless on this, going after everybody who was involved in this murder. So I wouldn't be surprised if they believe they can put together a case they can prove beyond a reasonable doubt, or they believe that they can prove beyond a reasonable doubt that they may bring charges.
And to what extent do they, you know, if they think that Wendy was involved, prosecutors tend to they don't want to lose, right? They don't want to spend the taxpayers' money on it. And you can think all you want that this X, Y, and Z is involved, but you wait, because you only have one shot as well. Does time sort of help them with Wendy, if indeed they do believe she was involved? That you've got Charlie incarcerated, you now have Donna convicted, and these others. Something could come out, right, to bolster their case if, you know, before they pull the trigger, because if you indict and you lose, that's it.
Right. They're only going to get one chance at this, especially having gone through all these other trials. I do think, you know, in the court of public opinion, it's hard to find juries after you go through a number of prosecutions on a case that haven't heard of it or don't know about it, especially a case like this that's gotten so much attention over the years. So it really can kind of become a little bit of a domino effect. Usually, time is on the side of the defendant, not the state. So the longer things go on without charges, that tends to fall more in favor of the defendant most of the time, because people forget things, don't say things, witnesses disappear, things like that. And in a case like this, I would think if these co-defendants were going to come up and testify against her or offer testimony for a reduced sentence or something along those lines, that probably would have happened.
And Katie McManaway likely has, because she definitely went after Charlie. Even though she was convicted, she's looking for a little relief on the back end. Donna's 75 years old. Her prospects of ever leaving prison are pretty low, are they not? Just doing the math, even if her appeal is successful, it takes so much time.
That's correct. I would be surprised if she ever is out of prison alive. I do think this is probably in most ways a death sentence for her. Florida has determinate sentencing, so you're going to do 85% of your sentence for somebody of her age. And we know people usually don't live as long once they're incarcerated. The prospects aren't good. Even on appeal, you know, even if she's successful, you still have to get over the hurdle of, if she's successful in her appeal, she gets a new trial, then she gets to go through a detention hearing, and the judge gets to decide whether or not she gets to be out pending her next trial. So a lot has to happen, and we're probably talking about years in the process.
All right, stand by, Sky. Let's get a break. When we come back, we'll head back to Ohio. We've been watching some unaired testimony from this case involving the little toddler. And now the defendant is on trial, and the jury has to determine whether or not she was legally sane at the time that she stabbed and killed little Julian. Stay with us.
The defendant is guilty of first-degree murder.
Convicted for the murder of her former son-in-law. How long will the matriarch mastermind spend in prison?
Was it worth it?
The sentencing of Donna Adelson, today at 3 on Court TV.
Tonight on Closing Arguments, convicted for the murder of her former son-in-law, Donna Adelson learns her fate. Vinny is back in the studio with a closer look at today's sentencing.
Closing Arguments, tonight at 8, 7 Central, only on Court TV.
We're turning our attention to Ohio this hour, where closing arguments begin tomorrow in the Toddler Stabbed murder case. Bionca Ellis, accused of stabbing a mother and her child in a seemingly random act outside of a grocery store last year. Prosecutors say that Ellis fatally stabbed 3-year-old Julian Wood in the face and the back, and she killed him in front of her mother, Margot. She was also stabbed, but she had to watch the horror of seeing her child stabbed to death. The defense doesn't deny that Ellis committed this murder, but the claim is that she was insane legally at the time of the stabbing. Court dark today because of Columbus Day. I want to catch you up on some unaired testimony. Let's do that now. Go back into the courtroom. This is the defense's final witness. This is a forensic psychiatrist who evaluated Ellis.
Mr. Mack talked to you about the interview. Did you observe her interview?
I did.
All right, at the police department.
Yes.
Again, another objective item for you to consider.
Yes.
And draw opinions from that.
Yes, to the extent of being able to observe her mental status.
Right. You could observe her mental status. You could observe the way she is talking. You can observe her word choices. You can observe her body language. You can observe a lot of things with a video. Correct?
Yeah. Yes.
And then you make a determination about it. Fair?
Yes.
All right, so let's turn our attention now, Doctor, to Exhibit K. That is your report, correct?
Yes.
Dated May 14th.
I'm sorry, Your Honor. Dated May 14th, 2025. We want to keep our dates straight here.
Thank you.
All right, Doctor. So let's start with the educational history. Correct?
Yes.
Okay. And in the educational history, she tells you about getting her diploma from ECOT, the Electronic Classroom of Tomorrow?
Yes.
Okay. And she reported that while in high school, she was not placed in any special education classes, and she was described her grades as pretty good.
Ms. Brown. So just read, that's okay, I'm just going to remind everybody. So just reading from that, I asked at a slower pace for the record.
Okay.
Thanks.
Sorry, Rob.
You're okay.
Special education classes, and she described her grades as pretty good, nothing noting that she was an honor student, right?
Yes.
Okay. So you were looking at that because educational history is important, right?
Yes.
And you were looking to see if she had an IEP.
I was.
Right. Can you tell the ladies and gentlemen of the jury what that is?
That is an individualized education plan, often indicating that students were provided special services due to educational needs.
And she didn't need any, did she?
Not according to her report, no.
Okay. And we have no reason not to believe that, right?
That's correct.
No, there was no other collateral information that was provided to you that would indicate that she had an IEP.
Correct.
All right. And she also made it a point to tell you, I think you had in your conversations with Mr. Mack, that she had no guardian and she had no payee.
Yes.
Right?
Correct.
And that is not uncommon for a person who is diagnosed with schizophrenia.
That's not uncommon. I would say payee-ship is more common than guardianship. Guardianship is a pretty extensive legal process.
Right, but being your own payee, somebody else doesn't have to monitor their money. They are able to do things with their own money, right?
Yes.
When they are their own payee.
Yes.
Because if somebody else is given that status, then they would have to give, that person could not be able to function or deal with money matters.
That's generally the reason somebody would have a payee, yes.
Okay. But she had neither.
That's what she told me, yes.
Okay. So as Mr. Mack said, you went through then the relationship history, the medical history, the current medications, the psychiatric history, correct?
Yes.
And as you're going through those, you're finding out that she was in the hospital for various things, whether it be psychiatric concerns or some physical concerns.
She did report some physical health issues as well, yes.
And when she went in for physical health concerns, there were times that she was lucid, she was good. There was not one indication of any type of psychotic issue when it was just for health reasons.
I would expect that there would be some medical records that would suggest she was simply there for medical issues, yes.
Right. But because she has a history of it and a diagnosis, right, that would still be part of her file, it would be part of EPIC, right?
It would be listed as a diagnosis in her computer-generated notes, yes.
So when she went to Metro Health on May 24th of 2024, and she was seen for a medical condition, they said that there was no psychiatric issues noted, correct?
Yes, I have no reason to not believe that.
All right. And then let's turn to those Murtis Taylor records. She was frequently going to Murtis Taylor up until about June of 2023.
Yes.
Is that what those are what our documents tell us, right?
Right.
And then we have some Cleveland Clinic records that Mr. Mack went through with you, and it said that the patient, I believe on November 18th of 2015, psychosis and suicidal ideations.
Yes.
And then it says, patient has positive tox screen for THC. Per chart, patient denies drug use.
Yes.
All right. So can you explain to us, how does THC affect the medications that she's on?
I'm not entirely sure she was on medication at this point.
This was in 2015?
Yes.
Okay, fair enough. But obviously she's exhibiting some signs and symptoms of psychosis.
Yes.
Right? So would THC affect that?
It could potentially, yes.
And how would it affect it?
Sometimes THC or marijuana can cause people to increase the number of psychotic symptoms that they have.
Okay.
Let's get a break. We'll get you back into the courtroom for more testimony. And a reminder, top of the hour, our special coverage of the sentencing of Donna Adelson begins from Tallahassee. Stay with us.
I saw her coming, walking towards us, and I noticed she had a knife in her hand. She stabbed the back of the trunk of a car, and I got scared. But when I was pushing the car back, it fell over. And then she came at me. I moved. And she stabbed him in the side of his face. And then she stabbed me.
That was the voice of Margot Wood testifying about that horrific moment when the defendant, in this case Bionca Ellis, attacked her and her son Julian in the parking lot of a Giant Eagle grocery store in Ohio. 3-year-old Julian died from his injuries. Now Ellis faces life in prison without parole if she's convicted for his death and the attempted murder of his mother. There's loads of evidence that she did it. The defense says yes, she did it. Everyone agrees she did it. There's video. Now the defense says, well, she's suffering from schizophrenia and was insane legally at the time of the stabbing. Let's go back into the courtroom now. We've been watching unaired testimony in the trial that we were prohibited from showing until now. Let's pick it up with more from the defense's final witness.
All right, on February 24th of 2024, you reviewed some documents from a Dr. Hillman?
Yes.
That would be page 5 of your report?
Yes.
All right. And Mr. Mack read you all about the murder, the El Chapo, all that. And then, but this part wasn't read. No suicidal ideations, homicidal ideations, has been homeless, reports that she is staying in a, it says tent, I'm going to assume that's tent, denies drug use, denies THC use, and he diagnosed her with schizoaffective disorder.
Yes.
All right. And so even after she said all that stuff, or was articulating that stuff, this doctor said there was no suicidal ideations. What would suicidal ideations be?
Thoughts to hurt herself.
And how about homicidal ideations?
Thoughts to hurt others.
So he didn't see any of that?
Yes, that's what he's reflected here.
Okay. And then we move on to North Coast Behavioral. Correct?
Yes.
And you met with her for your interview. What date was your interview, ma'am?
My first interview with Miss Ellis occurred on July 3rd of 2024.
And that was for purposes of competency?
Yes.
Okay. When did you meet her for purposes of sanity?
That was February 19th, I believe. Double check.
Of 2025?
Yes.
Okay. So at that time, is it fair to say that now you had more reports from North Coast Behavioral, more observations of how she was acting, correct?
Yes.
Okay. And then you proceed to have your interview with her.
Yes.
Well, before we go there, and before they make their determination with regards to competency, Miss Ellis has a couple of episodes or incidences at North Coast. Is that fair?
That's correct.
All right. And she assaulted a peer.
Yes.
Okay. And there were 2 incidents of physical assault, correct?
I recall that she assaulted a peer. I know she made some threats. I believe this was documented in Dr. Testa's report. She became aggressive verbally with a nurse as she did not like the color of her cup.
Okay. And at that time, ma'am, was she on medication?
I don't believe she had received medication. That was not until September 23rd. The assault on a peer occurred on September 13th.
Okay, on the pier. But what about the one, the next one?
I believe that may have predated it. I don't have a time or date on the verbal assault of the staff member.
All right, but she didn't like the color of a cup, right?
Yeah. Yes, that's what's reported.
Okay. And then you go on to family psychiatric history. You talk to her about legal history, correct?
Yes.
And then you talk about this Bakersfield incident, all right? And you indicate that she stated, "What do I need to do to stay in jail?"
Yes.
Is it fair to say, doctor, that she wanted to go to jail?
It appears that way.
Okay. And so she was asking to go to jail because she was being kicked out of an emergency department that she wanted to stay at.
That would be a rational conclusion. I don't know that for certain.
Well, I think you typed a whole bunch of stuff in here, and it says that per the report, the Bakersfield report, Officer Vining reported that on January 26,
Nice and slow.
2024, he was flagged down by Kern Medical for a subject, Miss Ellis, refusing to leave the property. He said that Nurse Paula, P-A-L-A, advised that Miss Ellis was partway through being seen by medical staff, had refused further treatment, failed to leave the property upon being asked by the security, and demanded that the police be called.
Yes.
Nurse Paula stated that Miss Ellis became combative and kicked two of the security guards.
Yes.
Okay? She stated during the assault, Miss Ellis used her right leg to kick Paula one time in the stomach. I then contacted Miss Ellis, who was seated on the floor of the hospital room. When I asked her what was going on, she told me that I needed to take her to jail because she had just assaulted hospital staff. What does that tell us about her?
I guess that she wanted to go to jail.
Okay? And she assaulted somebody because she knew that if she assaulted somebody, she would go to jail. Is that fair?
I think that would be a rational conclusion.
A rational conclusion, right?
Yes.
Because she was able to travel from Cleveland, Ohio to Bakersfield, California. She was able to purchase a ticket. You agree with me?
Yes.
She got herself on a plane.
Yes.
And she traveled to California and brought a suitcase with her.
I don't know about the suitcase to my recollection, but I would agree with those other things, yes.
Okay, that's what typical.
All right, Sky Lazara is still with us. The insanity defense. Some states, like Utah, they don't have an avenue like this in Ohio where not guilty by reason of insanity is on the books, but the burden's on the defense. What's your take on the likelihood that they could be successful? They've had two experts come in. You could argue one was better than the other. State had their expert. What's your take?
Experts are always hard, especially when you have competing experts, because a jury, sometimes they would just become a wash. In Ohio, the burden is on the defense in this case to prove by preponderance of the evidence, or more likely than not, that she was mentally ill at the time of the offense, or at the time she committed the offense, which is a full affirmative defense for her. I think these are tough cases. This is different than a competency type evaluation that would be done to see whether or not she could stand trial. This really focuses is at the time, and those are pretty difficult. I think you really have to do a good job, and your expert has to be really dialed in. And you have to have a diagnosis that makes sense, that a person was in a psychosis state when they committed the offense and are now competent through medication or whatever that is, because they're seeing an entirely different person sitting before them in the courtroom.
Bionca Ellis clearly had mental health issues. She had schizophrenia diagnosed, but the state points to a couple things, an intent, where there's video of her at a knife, getting a knife at a thrift store. She's going through, looking at different ones. This is before she even goes to the grocery store. And they're saying that this was a woman who was angry because she had been treated poorly by police and was intently looking for this knife to steal from a thrift store. And jurors saw this. This seemed like a very clear there was an objective here for her, the state argues. How important is her actions before the murder to establish that she did know right from wrong?
That's the entire idea or gist, or what has to be proven or disproven during this, is her mental state and the actions that she takes before. If you can show that they're deliberate and thought out and methodical and planned, that goes, more in favor of the state in a case like this, to show that she wasn't insane or she wasn't in the mix. We know she has mental health problems. That's not disputed. It's what she was like at the time. Was she in such a mental state or breakdown that she couldn't form the mental state to commit a crime? And when you start looking at what she's doing before, and of course the state's going to have a theory that she was planning it and this is why she was doing all these things and it was methodical and she was angry, and the defense is going to counter back and say, this is all part of the same episode where she just was completely not in her right mind. But I do think things that seem or can appear or be argued to be deliberate leading up to the time, especially shortly before the crime is committed, is going to tend to, disprove this idea of her being in a mental state.
Yeah, we'll see what happens. Sky, thank you. Let's get a break. When we come back, we'll have more. And then we're looking forward to Donna Adelson's sentencing. Our special coverage begins at the top of the hour live from Tallahassee with our Julia Janae. Stay with us.
The defendant is guilty of first-degree murder.
Convicted for the murder of her former son-in-law. How long will the matriarch mastermind spend in prison?
Was it worth it?
The sentencing of Donna Adelson, today at 3 on Court TV.
Tonight on Closing Arguments, convicted for the murder of her former son-in-law, Donna Adelson learns her fate. Vinny is back in the studio with a closer look at today's sentencing.
Closing Arguments, tonight at 8, 7 Central, only on Court TV.
Now, we've been watching key testimony in the murder trial for defendant Bionca Ellis. Prosecutors say that Ellis followed victims Margot Wood and her 3-year-old Julian out of a grocery store in North Olmsted, Ohio, and attacked them in the lot. Julian suffered fatal stab wounds. Mother was injured but survived and testified. Let's go back into the courtroom now. More from this forensic psychiatrist called by the defense, Dr. Sarah West. This is Cross.
Typical ordinary people do when they go on a trip. They pack their belongings, get a ticket, get on a plane, and they get on the plane and they go.
Yes.
Right?
Yes.
Okay. So let's continue here. When I asked her what was going on, hold on a minute here, I lost my place. She stated during the assault, Miss Ellis used her right leg to kick Paula one time in the stomach. I then contacted Miss Ellis, who was seated on the floor of the hospital room. When I asked her what was going on, she told me that I needed to take her to jail because she had just assaulted hospital staff. I subsequently placed her in handcuffs without incident and placed her into the rear of my patrol vehicle. Officer Vining reported that while in the patrol car, Miss Ellis stated she wished to do something to remain in custody for a minimum of 2 weeks, but would not elaborate as to the reason why. She stated, "What do I need to do to stay at jail?" They conducted a records request, the police, and they found no local warrants or probation, parole status located, no prior contacts. She was determined to live in Cleveland per a located driver's license amongst her personal property. So she was able to bring her personal property with her to identify who she was. She was then transported back to the detention center, okay? And she was charged with battery and trespassing, okay?
Yes.
So she had a very specific plan in that instance. Do you agree with me?
She did appear to want to be in custody, but would not say why.
But she specifically wanted to stay 2 weeks, correct?
Yes, she does mention that.
Okay. So then you continue to look at more police reports and the ones that Mr. Mack went through with you with regards to Bakersfield report here in Cuyahoga County in Cleveland, the North Olmsted. You talk about the Florida one. Again, they're able to take a plane, and you saw there were videos to that one, right? Did you review that video?
I did not look at that video.
Okay. That she was fully dressed in a very nice outfit and was at a very nice hotel, and again had specific plans to want to stay in Florida.
So I'm just going to ask a question as opposed to some of the factual basis that you're placing on the record.
Well, these are all in...
Well, she indicated she didn't see that video. I'm not limiting you. I'm just asking, she didn't see the video, so she can't evaluate it. Sounds like you placed that on the record of what it was. But
all right.
I'll ask you to just continue.
All right. I will withdraw that. So you did not observe the video of that?
I did not.
Okay. All right. Fair enough.
Thank you.
But there was a police report that you reviewed, and you put that she wanted to stay in Florida as well. Is that fair?
Yes.
So then when you look at violent history, violence, that would be considered a risk factor. Don't you agree, Doctor?
She did have violent behavior, yes, in early 2024.
All right. And this is all during your meeting on February 19th, correct?
Yes, the information that she reported to me would have been reported to me on February 19th.
All right, and that was 8 months later from the event.
Yes.
Right? And that was pretty much all of her self-reporting.
Yes, I'm generally pretty good about attributing where the information came from.
Okay. And so she is able to speak to you, correct?
Yes.
And you ask her questions because you say that she's oriented, alert to date, time, location.
Is there a question?
I'm getting there, Judge.
Okay.
Thanks.
Sure.
So when you are asked in your report, you describe her mood and stated it was very calm, and you actually use the word serenity.
She used that word, yes.
Oh, so she was very calm and serenity. So can you tell me what she meant by serenity?
I think she was feeling more peaceful than she had before. Moods are typically quotes directly from the evaluee.
And serenity was the word that she used.
Yes.
So she's got a good vocabulary. Would you agree with me?
I agree that that is, yes, indicative of a reasonable mastery of the English language.
Yes. And so then you go through and you start talking about the event. Is that fair?
Yes.
All right. And again, all of these, I have been having some prior experience, a deity's way of believing in things. This is at the bottom of page 9, prior to your diagnostic impression. Dinosaur bones, my astrological signs. Can you give me some context to that?
Oh, yes. My apologies. So this actually is on July 3rd of 2024. We are not speaking of the events of June 3rd, 2024. I'm simply recapping my assessment of her mental status at that time in an effort to contrast it to how she presented on February 19th.
So that is not part of your interview on February 19th?
No, I say Miss Ellis's presentation during the evaluation on February 2025 differs vastly from her mental status during our initial interview on July 3rd, 2020.
All right, let's get a break. They'll be back at it tomorrow in Ellis, but when we return, we're going to head to Tallahassee, Florida, where Donna Adelson is getting ready to be sentenced. Julian Janae takes over. Stay with us.
We, the jury, find as follows as to count 1 of the indictment, first-degree murder. The defendant is guilty of first-degree murder. Mrs. Adelson, control yourself.
Welcome back to Court TV Live. I'm Julia Janae here live in Tallahassee, Florida. Thank you for following along with us as we are looking ahead to the sentencing of Donna Adelson. That moment you just saw was about a month and a week ago, where she was sentenced, or convicted rather, of first-degree murder in the death of Dan Markell. She became the 5th person who was convicted in this murder plot that killed her former son-in-law. He was a law professor here in Tallahassee at Florida State University, Dan Markell. That happened back in 2014. It took over a decade to bring his mother-in-law to justice, and now she faces life behind bars. Now, since her conviction, she filed a motion for a new trial, and it was swiftly denied by the judge, but it does give us an indication of what she may bring up on appeal. Here are some of the main issues in that motion for a new trial. She alleged juror misconduct. She said that the jailhouse informants who testified against her were not credible, and she also claimed that the judge forced her to make an uninformed decision on whether or not to testify. We're going to talk about all of these issues with our guests, but first, let's take a look back at that testimony of the jailhouse informant. One of them was dubbed Donna's jail daughter, Drina Bernhardt. She told the court that Donna offered her money and drugs to recite a handwritten script for police containing false testimony that Donna Adelson hoped would help get her off of these charges. Let's take a look back at that testimony. It was on day 6 of this trial.
Did she ever mention to you a state witness by the name of Catherine Magbanoa?
Yes.
And was Ms. Magbanoa somebody that was known to you?
Yes, I knew Miss Magbanoa from being locked up with her years before.
And how did she first bring up Magbanoa to you, or did you bring Magbanoa up to her?
I can't remember exactly how it was brought up. I just know that it was brought to her attention.
Brought to her attention that you knew Magbanoa?
Yeah.
Okay. And at some point, did the defendant try to recruit you to become a witness for her in this case?
Yes.
How did she first approach you about that?
She asked me if I would be willing to do it, and I said yes.
Okay. And was this topic discussed one time or more than one time?
More than once.
How many times can you estimate? A lot?
A lot, yes.
At some point, did she prepare a script for you of exactly what she wanted you to testify to?
She did.
I'm going to approach and show you. Whose notebook is this?
That's mine.
Okay. And whose handwriting is this on this first page?
That's Donna's, Miss Anderson.
Okay, so she wrote this in your notebook?
Yes, ma'am.
This says that Kay told you that she told Charlie on the night of the murder that some friends of hers went to Tallahassee and killed him. Did Kay ever tell you that?
No, ma'am.
Okay. She asked him to give her the 1/3 of $1 million that he was going to pay his sister so that she could relocate with her children to Miami. He went crazy on her. He said that that was going to be an offer to his brother-in-law not to kill him. Did Kay ever say any of that to you?
No, ma'am.
But that's what Mrs. Adelson wanted you to come in and tell this jury.
Yes, ma'am.
Did she give you anything or promise you anything in exchange for reciting this script?
Well, I was in jail. I received packages and phone calls, and I was promised things as well.
What type of packages?
Packages are in jail just like a bunch of basically gas station food, but it's exciting when you're in jail.
Okay, and what about phone calls? What do you mean by that?
Just the phone calls are very expensive from jail, so she would let me use her phone to call my mother and other people.
Okay, and you said she promised you other things in the future. What other types of things?
$10,000, a grand piano.
What else?
She promised me cameras, but
none of that came to fruition?
No.
Okay. And what about pills? Did she mention anything to you about pills?
Yes, that if I needed pills, that I could call a doctor named, I think, Obed. I think that's his name.
Okay.
Yes.
And that person would write you some prescriptions?
Yes, ma'am.
And how were you going to get these other items, like the $10,000?
The money would be through something called Zelle.
Okay. And who was going to send the money through Zelle?
Harvey.
That's her husband, Harvey Adelson?
Yes.
This was big evidence inside of the courtroom for the prosecution because it showed how Donna acted after she was arrested when she was behind bars. Let's talk about this with our mitigation specialist and defense investigator guest who's with us, Monica Jordan. Monica, great to have you on. You are also very connected to this case. At the very beginning, you worked with this plea deal for the very first person to flip in this case, Luis Rivera. And we'll talk about that soon, but I do want to get your reaction to the informant who testified. How difficult is it for the prosecution to have a very credible informant on the stand, and what does the defense do when they're trying to shake that up?
Well, historically, what you want to do is you want to try and impeach the informant. But Georgia had a good source. They had a whole document written in Donna's handwriting outlining the script that they wanted she wanted the witness to testify to, and it was inaccurate, and the informants claimed this is not what Katie told me while I was in custody with her. So Donna's desperation to continue to control the narrative kind of blew up in her face. But for the defense, to impeach somebody like that is the best way to try and attack their credibility. And it just did not appear that they were able to do that because the informant was very credible, and ultimately the jury convicted Ms. Adelson.
So I mentioned your involvement in this case. Can you talk a little bit about what it was like so many years ago working with really the first person to be convicted in this case?
Yeah, I was on the Luis Rivera team. He had two great lawyers, David and Chuck Collins. It's a father and son team. They brought me in to primarily litigation end of this because the government was seeking the death penalty. So in those situations, I come in and try and either get the death penalty off the table or we go to trial. What those lawyers did, which I thought was brilliant, I was terrified at the time, looking back, it was brilliant, is they demanded speedy, and that forced the government to offer us something in exchange for testifying. The hardest hurdle in that was not convincing the government to offer that deal. The biggest hurdle was to convince Luis Rivera to take it, because ultimately he knew by testifying against Sigfrido Garcia and Katie that would ultimately be a life sentence. Not a life sentence in prison, but ultimately a life sentence for the rest of his life because he had testified.
And that's interesting, especially with the fact that no one faced the death penalty in all of the trials that we did have in this case, but life in prison is what we're anticipating in less than an hour, the judge is going to say for Donna Adelson. Monica, stand by, because I want to talk about another part of that motion for a new trial, and that's the juror misconduct that's alleged by the defense. And I want to take a listen back to some of the after or post-verdict comments that these jurors made. I was inside of the courtroom. I could see these jurors throughout the trial, and one of them in particular, the foreperson, she was very vocal on her social media after it. Her TikTok handle was Lacey with a J, so JC. And here's a bit of what she said and what another juror said after the trial that the defense said. Take a listen.
Sort of standout evidence for you that made you go, she's guilty?
For me, the bump operation was a big part of that, and the code. Innocent people don't speak in code, and that was what really was pushing me towards a guilty verdict. Her, as well as when the operation happened and she was handed that sheet of paper, just taking the paper and putting it straight into her bag without looking at it. I'm not taking anything from anyone and putting it in my bag before looking at it.
Okay, that was one of the The jury foreperson, again, she did take to social media. And one of the things that the defense had an issue with is that she mentioned that she was serving as a juror. She didn't mention the case, but before the trial really started, letting her followers and friends and family know that she was going to be on basically this break while she served. And the judge said that that was not an issue. It didn't mention the case, and that's what he instructed these jurors not to do. So he didn't have an issue with what she put on TikTok. But Monica Jordan, bringing you back in, how does this work oftentimes when you're on the defense side? Is it typical to start looking into the jurors when you're looking for mitigation to help the defense as they move forward to either sentencing or an appeal?
Absolutely, but that process starts long before they're ever seated. You get the jury voir dire on a big capital case like this about 2 weeks before, and you start conducting your research. So you have a little bit better idea of what you're working with, and so it's not just a surprise of only having a day or so to identify who you potentially would want on a jury of this magnitude. The interesting thing is that the jury instructions are very clear about what they can and cannot do when it comes to social media research, talking to the media. But after the trial, they're actually given an instruction by the court, and Judge Everett did that here, and it says you're free to talk to the media. You don't have to talk to the media. You can talk to people. You don't have to talk to people. The fact that she indicated that she was that she was going to take a break and she was on a case, she may have been like throwing some breadcrumbs, but Everett didn't see any fault in that. But that will be an issue that's raised in a 3850 appeal. And it could be potentially raised in the direct appeal after she's sentenced, because in that direct appeal is when they're going to discuss all of the things that they thought Judge Everett got wrong. Once that's either affirmed or sent back for a new trial, then they'll start the post-conviction proceedings, and all of these issues will become paramount again when they're doing the post-conviction appellate remedies.
Oh, yeah. So it sounds like you're saying we may even see some more information that comes out on appeal when it comes to this look at the jurors. There's another thing that's mentioned in that motion for a new trial, and that's this allegation that the judge forced Donna Adelson to make a decision when she wasn't ready on whether or not she could testify. And we all watched. I was inside of the courtroom for this when she was repeatedly given chances, but she didn't take it in order to make a decision as to whether or not she would take the stands. Let's take a listen back to that moment and talk about it, Monica, on the other side.
Concerning those rights as to whether you will remain silent or whether you will testify, have you made a decision concerning this matter?
I haven't. I'm not prepared to make that decision. This decision affects the rest of my life.
Mrs. Adelson, you're in the same position as every other criminal defendant who faces trial. Ultimately, you must decide whether you will testify or whether you will not. I cannot make you testify. Your attorneys cannot make you testify. But ultimately, you must choose whether you will testify or not.
I don't have to choose. I was hoping I would have some time to speak to my attorneys.
This has already been discussed, ma'am. What is your choice? Mrs. Adelson, the question remains, as it relates to your right to remain silent and your right to testify, what is your decision concerning these two rights?
At this time, I don't want to testify.
Very well. As I've previously stated, the jurors will be instructed that your silence cannot be held against you in any way.
Monica, this is a moment that was brought up in that motion for a new trial, and the defense goes so far as to say not only did the court force the defendant to make an uninformed decision, he threatened to hold counsel for the defense in contempt of court because they were continuing to speak with their client about this important decision that she has to make. Do you ever see on appeal a success when someone had an issue on their right to testify or not to testify?
I have. But I would like to say when we talked about some of those other appellate remedies, there's a saying in post-conviction work, and that is for every $1 that they spend on the trial lawyer, they'll spend $2 on the appellate lawyer. So they're going to bring in the best appellate people they can to Monday morning quarterback this, which is absolutely her right. But there's a little bit of gamemanship here and a little bit of strategy. They are continuing to lay the foundation to say that she made an uninformed decision, even though they have probably been talking about this since day one, whether she would testify or not. The fact that she says, I've not been provided enough time, I can't give a decision right now, I can't say whether I want to testify or not. Well, at what point does the judge say, I mean, she could do this for 6 weeks. Like, what time frame can you put on it? He gave her plenty of time, and so I think that's a little bit of an unfair characterization to say that she wasn't provided time. I thought it was pretty fair, but listen, my opinion won't matter. The First District Court of Appeals will be the first one to answer that, whether Judge Everett did it wrong or not.
Oh, absolutely. And the prosecution's response on that will be she had the lunch break. She had multiple breaks and sidebars with her attorney before that. Monica, stand by. We've got a lot more ahead. We're again waiting for things to kick off inside of the Leon County Courthouse. There's a live look at the seal. The parties are not inside yet. We've got about 45 minutes before that hearing begins. When we come back, though, we're going to talk to our guests about a big question that's on everyone's mind, and that has to do with the key witness, Wendy Adelson.
The defendant is guilty of first-degree murder.
Convicted for the murder of her former son-in-law. How long will the matriarch mastermind spend in prison? Was it worth it? The sentencing of Donna Adelson, today at 3 on Court TV.
Tonight on Closing Arguments, convicted for the murder of her former son-in-law, Donna Adelson learns her fate. Vinny is back in the studio with a closer look at today's sentencing.
Closing Arguments, tonight at 8, 7 Central, only on Court TV.
Welcome back to Court TV Live. I'm Julia Janae, coming to you live from Tallahassee, Florida, where in the courtroom behind me, we are expecting the sentencing for convicted killer Donna Adelson to begin. What's she going to be wearing? We don't expect that she'll be wearing the same civilian clothes that she wore during her trial. She should, now that there's no jury, be in jail clothes. The matriarch mastermind returns to the Leon County Courthouse at least 3 p.m. She may already be inside, and she's going to be facing a mandatory life sentence for first-degree murder, conspiracy to commit murder, and solicitation, all in the death of law professor Dan Markell, her former son-in-law, who was the father of her 2 grandchildren. We'll bring you every moment from inside of the courtroom as soon as things start up there. Our Court TV cameras are already there. But while we wait for things to start at 3 p.m., let's take a look back at some key testimony from someone who has been very important to this trial and on this case. It's her daughter and Dan Markell's ex, Wendy Adelson. A lot of questions bouncing around about whether or not she will be charged. At this point, she has not been arrested or charged. She maintains that she was not involved or even aware of the plot to kill her ex-husband. Let's watch.
Did you say in that interview for court and counsel, I'm referring to page 288, lines 24 through 289, line 1, quote, "My parents have more reason to dislike Danny than almost anyone else"?
At that point, I was sitting with law enforcement for 6 hours and had just been told that Danny had been shot. So I was in shock, and I was trying to help the police think of anything I could possibly think of that would be helpful.
And are you suggesting that after 6 hours you became fatigued to the point that you started saying things that weren't true?
No, I didn't say anything that wasn't true. I just was in shock. I just kept talking and talking and talking.
Did your mom ever called Dan Markell any disparaging names around this time frame?
She did.
Okay, including piece of
Yes. Yes.
A narcissist?
Yes.
A bully?
Yes.
A bastard?
Yes. I think my mom thought my life in Tallahassee wasn't good.
Is it true that you never would have left Dan Markell without your mom's suggestions?
Objection, lady. Overruled. She may answer the question based on her own knowledge.
I would have left Danny regardless of anyone else's input. I was very unhappy.
Did you ever write that you would have never left him without your mom's suggestions?
I don't remember saying that.
Please refer to tab 41 and see if it refreshes your memory.
I do say here I wouldn't have done it on my own.
Okay. Do you specifically reference your mom?
I say my parents and brother's suggestions and support.
After that testimony, Wendy Adelson hugged her father, who was in the gallery, and did not return to this courthouse. We don't expect her to be inside today. Let's bring in our guest. We have with us former state attorney for Palm Beach County, Florida, Dave Ehrenberg, someone who also knew Dan Markell and has kept in contact, been on panels with his mother, Ruth Markell. Dave, it's so good to see you. 10 years ago, 11 years ago, did you think we would be here with Dan's mother-in-law being sentenced?
Julia, it's good to be with you. Yes, I thought that one day justice would come for every member of the family that was involved in this, but I guess I didn't anticipate it would take so long. And when my friend Danny was murdered, no, I did not believe at that time that his family would stoop to this. I mean, who does? What kind of in-laws would ever do this? Especially these are individuals who are reputable in the community, and this would be a first time for them. They've never been involved in anything like this. It's not like any of them had any rap sheets. But then as time went on, it kept pointing to the same people. And then I knew her day, Donna's day of justice, would be upon us. It just took many years, and I don't think it's over yet for members of the family.
And that's the question that's on everybody's mind, Dave. People thought maybe right after the conviction there would be a grand jury indictment. Here we are over a month later. No indictments have come down. What's this like for a state attorney's office? I know you've had so many cases that have been lengthy like this one. Even one that comes to mind, a high profile one, the killer clown one that you all followed for so long. What's this like on the prosecutor's side to continue to follow a case this long, or to even make what could be a more difficult decision to not go forward with charges?
Well, the killer clown case, that was a cold case, and it took 27 years till we finally got a breakthrough. Here, the evidence is there. The whole case is cooked, meaning that they've got what they needed, either charge or don't charge. I don't think they're waiting on any additional evidence, because if they're going to charge Wendy, and I think they will, they've got the evidence to do so. It's a matter of when, not if. And my prediction is that Wendy will be indicted by Thanksgiving. I don't base that on any inside information. I know Jack Campbell, the state attorney. He has not told me anything. I'm doing this based on what I see in the public and just my hunch that if Wendy were not in the crosshairs of the prosecutors, they wouldn't have spent so much time talking about her at the trial, to the point that the jury foreperson who you showed on camera recently, just in the last segment, she came out and said, yeah, of course she was involved, and I do think she should be charged with the crime. Well, if the jury foreperson of Donna's trial is convinced that Wendy was involved and should be charged without even half of the evidence coming out against Wendy, because it wasn't her trial after all, then don't you think that Wendy is next?
It feels like there is an abundance of evidence, because to your point, we heard so much about Wendy in that trial, way more than we heard in any of the other trials. So it seemed like they were building their case. In terms of Donna Adelson today, we're anticipating, of course, she's going to be inside that courtroom, but we don't know if she's going to speak. Her attorney said it's likely, but they also said it was likely she was going to testify at trial, and that didn't happen. What do you think?
I think she probably speaks. She is, to me, someone who is a megalomaniac, someone who believes she's bigger and better than everyone else. She's someone of prestige and privilege. That's why it took her so long to say that she will not be testifying. She wanted to testify in the worst way, but her lawyers leaned on her over and over again, implored her not to do so. And that's why she was struggling with it. And eventually she gave in to her lawyers. Remember, there was a pre-trial hearing where she took the stand and she spoke at length, and it was a disaster. She came across as not credible. But I think at this stage, Donna is going to say, you didn't let me testify in the last trial, and that's why I lost. So I'm going to take the stand now because it's what I want to do. That's the conversation I envision happening right now.
We are all waiting for that moment to happen. Dave Ehrenberg, thanks so much for lending us your time. I know we have to say goodbye to you, but thank you for being with us and weighing in on this important sentencing. Coming up, Donna Adelson is soon going to learn her fate, and we are live here in Florida for all of it. Also ahead, we are going to keep you updated on the case out of Ohio. Court TV crime and justice correspondent Matt Johnson is going to let us know what's happening in the Toddler Stabbed murder trial for Bionca Ellis.